So, as you all know, that today March 21 is not saying. So, matters pertaining to program matter that you call. Certain matters pertaining to program that you not call, if you take it by this word. So, normal notice status here, and already have this head. So now, if any mention, as per notification, if any mention can be made, pertaining to this way, can be made before the single bench of honorable Mr. Justice C.J. Media. And mention, any mention regarding single bench of honorable Mr. Justice Justice now, can be made before the single bench of honorable Mr. Justice.
Item number matak motion item number 1.
One. Item number 1.
May I please, your lordship? Allegation is under section 392, my lord. So let the case diary be called for, my.
Mr. S. Alim, learned counsel for the petitioner. Also Mr. R. Kaushik, learned additional public prosecutor. Let the case diary be called for. Fixing.
My lord, 6th of August, my.
6th August for case diary.
Outline.
Item
Item number 53 of court number 21.
No, 21.
Viswadnath.
Item number 2 of court number 21.
May I please, your lordship? This application under section 397.
April beginning. Take it from that side. Yes.
This application is under section 397, it is section 401, lordship, for revision of the ex parte order, lordship, whereby the learned court directed to pay 20,000 per month for the respondent wife and 10,000 per month for son, to 30,000 only per month, lordship. Against that order, this revision was filed. Only the fact that this order was challenging the legality of that order, because of asset and liability as per Rajnesh versus Neha. This mandate was not followed by this court, lordship.
Okay, we
May
are
I-
issuing notice.
May I peruse this husband, lordship? To deliver.
No, we are issuing notice.
Lordship, as per earlier IA, opposite party advocate was represented, and this order was, their name was
Today,
reflected in this.
no name is shown in the cause list.
Yes, name was not shown. Lordship. Well, basic point is that this is the legal fund only, lordship, because Honorable Guwahati High Court also
No,
gave
but
the same matter.
no notice has been issued. Neither any notice has been issued.
Yes, notice are already issued, because 170, IA number 170 was already disposed of, lordship, and learned counsel
That is for
appeared.
condonation of delay.
Yes,
That is
delay was condoned.
That is a different case.
Yes.
In this case, you have to issue fresh
Lordship.
notice.
Yes. Lordship, there is a ISO, till then still proceeding may be still, lordship, because there is a acquisition proceeding is there, lordship. Till then, lordship,
No stay without hearing the respondent.
because till then, lordship.
This is question of maintenance only. You have to.
Yes.
Mr. What is your name?
P. Bora, lordship.
P. Bora. Learned. Your name is not reflected in the cause list.
But we have filed Kalanama, lordship. My name is there.
Your name is also not reflected. That
But-
heard Mr. P. Bora, learned counsel for the petitioner. This revision petition under section 397/401 of the Code of Criminal Procedure Command
Lordship, may I submit one thing? Because earlier also notice was issued 3 times to their addresses, but it was not received and returned unsharp. So we requested to the personally to Justice Service through family court. This was allowed by the planning court.
No, but here you have to take you through usual course. In family court, case is pending.
Is pending.
Or 01 of the Code of Criminal Procedure, 1973, read with section 19 within bracket 4 of the Family Courts Act 1984, impugning the order dated 2/8/2023, passed in FC criminal case number 614/2019, passed by learned Principal Judge Family Court number 2, Kamrup Metro, whereby the present petitioner was directed to pay monthly maintenance allowance of rupees 20,000 to his wife, that is respondent number. That is respondent number. That is the respondent, and rupees 10,000 to his son. Issue notice to the respondents through registered post with AD. The notices may also be sent to the respondent through the learned Principal Judge Family Court. Family Court number 2, Kamrup Metro, Guwahati, where the FC within bracket criminal case. This is disposed of.
Pending.
This is,
Execution criminal case was pending.
what is the number?
Execution case number criminal number 35 of the 2000.
Where the execution within bracket criminal case number 35/23 in connection with FC criminal case number 614/2019 is pending for execution. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on eighth of August.
Highly okay.
Same order. The interim we will consider after.
Consider on the rest. Hello.
Wait, please, Your Lordship. Milord, in this case, Milord, I was convicted, Milord, under section 138, Milord, of the Negotiable Instrument Act, Milord, and was sentenced to undergo simple imprisonment for 4 months by the learned Chief Judicial Magistrate, Milord. The conviction and sentence, Milord, and to pay compensation of rupees 4 lakhs, Milord. The order, the relevant part of the order is, Lordship. We find it at.
Now, where are you now?
I'm outside, Milord.
On bail.
Yes, Milord, appeal was preferred, Milord. Appeal has been dismissed, Milord, but I have not been arrested. Warrant has not been issued against me till now, Milord. And this conviction and sentence has been challenged, Milord. Lordship may kindly come to page 42 for a moment.
Page number?
Page number 42, Milord, Annexure 6. I was denied the right to cross-examine the complainant, Milord. Page 42, if you love.
Page 40.
42, Milord, 42, Milord. Annexure 6, Milord.
You took this plea before first appellate court.
Yes, Milord, this plea was taken.
How it dealt
It
with?
did not deal with the matter, Milord, specific.
No,
No specific. Milord.
you took that plea.
Yes, Milord. In the appeal, there was this plea was taken, Milord, and there is judgment of the Guwahati High Court, Milord, which says that one right to cross-examine is a fundamental issue, Milord. If that is denied, Milord, the whole case goes, Milord.
No, but if due to your negligence, you fail to cross
Even that, my
examine.
lord, it was the duty of the court also to appoint an amicus and cross examination. Here, what happened, lordship can see, I did not deposit a fine of rupees 1,000 for which the cross examination was.
Sudeep,
required.
NIA, yo.
Even the complainant was absent on that day, my lord. Your lordship, Peruse the petition number so and so filed by the land council for the complaint stating that on being requested by the land council for the accused, the complainant has not appeared today. Also peruse the petition number so and so filed by the land council for the accused stating that the conducting advocate A.K. Board Pujari is unable to attend court due to his illness and he is undergoing treatment at GMC. Record revealed that on previous date, cost of rupees 1,000 was imposed upon the accused for not examining the witness who was present in court. The cost has yet not been paid by the accused.
We
In
are
view of-
issuing notice. We are issuing notice.
Lordship, and I will be allowed to remain on previous bill, Lord.
You deposit 20% of.
There is judgment of the Guwahati Supreme Court, my lord, which has distinguished that fact, my lord. Lordship, may kindly see paragraph 3 for 2023 judgment. Excuse me. एक second.
What is this?
My lord, the deposit of 20%, my lord, is discretionary relief, that 2023 judgment. My lord. Earlier judgment has been distinguished, my lord. Paragraph 3 and 4, if you lordship.
No, now if without hearing the,
Lordship. Here also without hearing them, my lord.
No.
After hearing, if your lordship come to a conclusion, we should deposit, we will deposit, my lord. That was the fact situation here. My lord. May I read the 2-3 paragraphs? Paragraph 3, my lord. An appeal was preferred by the appellant before the session court, relying upon section 148 of the NI, the session has granted relief under 389 of the Code of Criminal Procedure.
where are you reading?
Paragraph 3, my lord, page number 3.
Yes,
An appeal was preferred
this
by.
is not an appeal, this is a
No,
revision.
the High Court relied upon the decision of so and so, my lord. Let just 3 paragraph. Paragraph 4. The High Court proceeded on the footing that as this court has interpreted the word may appearing the footing 148 as cell, the relief of suspension of sentence under 389 CRPC can be granted only by directing the accused to deposit a minimum 20% of the compensation amount. Order has been quoted, my lord. Now, if lordship takes up the relevant paragraph 6 and 7. What is held by this court? Page number 5, my lord.
Yes,
What is held by this court is that a purposive interpretation should be made of section 148 and I. Hence, normally the appellate court would be justified in imposing the condition of deposit as provided in section 148. However, in case where the appellate court is satisfied that the condition of deposit of 20% will be unjust or imposing such a condition will amount to deprivation of the right to appeal of the appellate, exception can be made for a reason specifically recorded. Therefore, when the appellate court considered the prayer under section 389 CRPC accused who has been convicted for the offense under 138 and Act, it always open to
no,
the.
we are not
It is
dealing
the
with a
jurisdiction,
petty. We are, first of all, we are not dealing with a
Appeal.
application under 389.
Lordship.
This is a revision against appeal.
Even the appellate court has the jurisdiction, the appellate High Court will have the
No,
concurrent law.
the discretion minimizes. More you
Yes.
go up.
I agree with that concept, my lord, but the thing is.
This
there is a
decision which you are relying
Lordship,
refers to an appeal.
lordship.
Your matter was dealt with in appeal by the first
By the
appellate
first
court.
appellate court.
Now you are in revision. You deposit 20%. I am heard Mr. A. Lal, learned counsel for the petitioner. This application under section 438 slash. These are correct sections.
I hope so, my lord.
No. Your hope will not do. You have to,
My lord.
because
438 is revisional jurisdiction, my lord. 442, my lord, is civil, my lord.
otherwise.
Yes,
every
the
time
power of the High Court for revision. Yes, correct. my lord.
BNS, BNSS. Petition under section 438 slash
Yes, my lord.
442,
Calling 438 is calling for record to exercise power of revision.
442.
For the power of the High Court powers of revision, my lord.
And what is 528?
528, lordship. Inherent power of the High Court. Saving of inherent power of the High Court.
read with section 528 of the BNSS 2023, impugning the judgment and order dated 13/6/2024 passed by learned additional sessions judge Sipsagar in criminal appeal number 31 within bracket 4 of 2018, whereby the first appellate court had upheld the judgment of conviction and sentence passed by learned Chief Judicial Magistrate Sipsagar in NI case number 55/2017, whereby the present petitioner was convicted under section 138 of the Negotiable Instrument Act, 1881, and was sentenced to undergo simple imprisonment for 3 months and to pay a fine of rupees 4 lakhs only. And in default of payment of fine, to undergo simple imprisonment for another 15 days. The issue notice to the respondent. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. As regards interim prayer for suspension of execution of sentence during the pendency of this criminal revision is concerned, the petitioner is directed to deposit 20% of the fine amount
Check
before
him on, Lord.
of the fine amount.
Please check him on, Lord. 20% of the check amount will be there, Lord. So,
What was the check amount
3 lakhs, Lord.
and what was the
4 lakhs, Lord.
fine amount? What is the law?
I think check him on, Lord. One,
Thinking will not do. You have to be
that's it. Get this one.
go through 148.
One of the whole.
Fine amount.
Fine.
It is not check amount.
That compensation was granted, Lord.
For fine amount before the original court deposited before the court of learned Chief Judicial Magistrate Sipsagar, and subject to such payment, such deposit made by the by the petitioner, in interim, the sentence imposed on the petitioner by the impugned judgment and order shall remain suspended. List this case accordingly after 4 weeks.
Available.
Number 4.
My lord, this is 489 application. AB 482, so 482 application. My lord, may kindly see the FIR,
What is the
then
offense?
lordship would be satisfied that what type of FIR is this? Kindly see page 16, my lord. I am reading the vernacular portion.
Offense is under what provision?
Offense, my lord, there are several offenses. First, 189. 189, that is bailable, man.
No,
Sir.
name the offense.
Old section के मान
All section I have not mentioned, but that is unlawful assembly.
Unlawful
Assembly.
assembly.
Yes, 189.
And
And
what
then
else?
126, my lord, wrongful restrainment. That is also value.
And then
And then, my lord, 118, that is causing hurt by dangerous weapons. Now here, Rashid, I will show that there is nothing of that kind. That is, this is the only section non-valuable. Then, my lord, 109, attempt to murder. This is also non-valuable, but FIR will not disclose this. And the next section is 351, my lord. This is criminal intimidation. This is valuable. Now, my lord, can you see FIR page 16?
109 and 118.
109, attempt to murder.
Here main whole section, my lord, 126, 107. No,
326.
sorry, 307.
326 and
307 is there.
And
324.
351
Dangerous weapon.
Yes.
351 is, my lord, 506.
You are objecting.
But I am showing, my lord, in the case, kindly see page 16, my lord, FIR. এজাহারকারী পারভেজ সাদিক সম্মানপূর্বক লসিম হাসিন
Yes.
সম্মানপূর্বক বিনীত নিবেদন এই যে আজি ইংরেজি 12/9/24 তারিখ দুপুরিয়া 1:30 বজাত নিম্ন উল্লেখিত আসামিগণে পরিকল্পিতভাৱে একগোট হৈ মোক হত্যা কৰাৰ উদ্দেশ্যে মোৰ ঘৰৰ সন্মুখৰ ৰাস্তাত মোক আগুচি ধৰি কোনো কাৰণ নোহোৱাকৈ হাতেৰে কিল ঘোষা মাৰাৰ উপৰিও মোক হত্যা কৰাৰ উদ্দেশ্যে চকা অস্ত্ৰেৰে মোৰ মূৰত আক্ৰমণ কৰি গুৰুতৰ ৰক্ত গুৰুতৰ জখম কৰাৰ উদ্দেশ্যে ভৱিষ্যতে মোক হত্যা কৰিব বুলি ভাবুকি দি মোক জখম কৰি গুচি যায়। So my lord, can you see everything is planning? That হত্যা করার উদ্দেশ্যে গুরুতর অস্ত্র করে ভাবুকি দিয়ে গুচি যায়।
No,
Now, my lord,
but
what
you
is that?
attacked also.
My lord,
There is an allegation that you have in fact attacked. You have assaulted.
my lord, that is true. That is appears to be true.
No,
That, but thing is this, my lord, allegations are between two political parties. My lord.
Maybe-
My lord, the present petitioners are the supporter of Congress party, and the informed party is the supporter of EDF party. So that is our clear case, my lord. And over and above, I will show your lordship that they belong to different political party. That lordship may kindly see.
No, what was the injury caused?
There are 6 lordships.
That is, my lord, that is.
What was the injury
Yes,
caused?
yes.
Injury is, my lord, injury is nothing. Here, nothing is there, my lord. My lord, I want to see, kindly see page 6 for why. There are 6, page 4. That the petitioner accused said that they are innocent and not involved in this case as alleged in the affair. The fact is that informant and petitioner are neighbors and there is a land dispute between them. In addition to land dispute, there is also political rivalry between the petitioners and the informant. Petitioners are the supporters of National Congress Party and informant is the worker of AIDF party.
This you have already submitted.
My lord, submit.
The fact is, we are concerned what injury has been caused.
Injury,
Therefore,
that's kindly go for.
case diary would be
But
necessary.
my lord, here, lordship, I kindly see page 9, my lord. How, what type of accused are this? This is page 9, this he is a teacher, my lord. He is the accused, he is a teacher. And this is identity card, my lord. And an old man. Then, lordship kindly see page 10, Alimuddin Shigar is the headmaster. He is the headmaster of Lakshmipur Girls, Kathari Girls School. So, he is my lord headmaster. And third one, my lord, he is also a teacher, science graduate teacher. Kindly see page 11. So, my lord, my only prayer is this, is it possible that the way the services there are their life, teachers will do this? Of course, my lord, there is a heated action between the two persons. And that two persons, I will have, my lord, we have disclosed this in our petition. Kindly see page 5, my lord. Page 5.
Yes, what is your submission?
So, my lord, kindly grant only prayer limited by our teachers, my lord. And only 5 was involved in the interaction of 5 have given a ghushi and he has also given a ghushi. Others are only concocted thing only to make the case non-valuable. So my lord, my humble prayer is lordship may kindly grant us interim bail.
But the allegation is against all the.
No, this is possible, this teacher man, and they are on the verge of retirement, one is 58 years, only 2 years service. So it is not believable. However, my lord, I am not saying that they are totally innocent, it will disclose the CD. My learned friend may produce CD, and till then, my lord, we may be kindly protected. We are all men, and we are all very reputed men of the society.
That the teacher, he was the main mastermind because he is involved in land grabbing cases and other immoral activities. This victim, he objected to that. And therefore, at his instigation and with his involvement, lordship, the present incident occurred. And in the FIR itself, it is said, lordship, that Murat Aghat Kore. And he, there is lordship, 7 stitch wound in his head, lordship.
7 stitches.
7 stitch wound, that is deep wound.
My lord, I am
So those
surprised
things are
on what
required
basis
for
he is submitting. On what basis he is submitting that I am the mastermind, what is the, is there anything in FIR?
Therefore,
that-
let
that
us,
case
let
that
us,
will
let
reveal
us
everything.
peruse
That
the
I am also calling, but submission should be on the basis of record. He is submitting everything all the year. I have also submitted.
No,
my
he
lord.
may be instructed by the,
Maybe instructed, but
On
instructor
next-
and
next
on
date, I
record,
will bring
but
on
there
record.
is vast difference
Those
in
things I will
instruction
bring on
and
record.
record. On my, I have also submitted, my lord, that kindly we are all men, teacher men.
you are
kindly-
yourself saying that there is vast difference between instructions and record.
Instruction-
Therefore, let us peruse the record. Thereafter, we'll
There,
consider.
no, there are lordship may consider the bail matter, but for the time being some protection matter.
No,
We are all men,
not now.
particularly this.
We are
this
fixing a short date.
Teachers well.
Heard Mr. M.U. Mahmood. M.U. Mahmood, learned counsel for the petitioner, also heard Mr. B.B. Gogoi, learned additional public prosecutor, as well as Mr. A. Ahmed appearing for the informant. Considering the nature of allegations leveled against the petitioners in the FIR, perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence, call for the case diary. When will you produce?
29.
Fixing
Short date.
29. We are fixing a short date. 29 for case diary.
Well, I expected that teachers should be granted bail because
But he is alleging,
he is alleging, but without any basis. There is no content in the FIR.
wait till 20.
Even
Yes,
the
his instruction as this stage.
instructor, I understand that, but FIR is well thought. An educated person,
Let us see. On 29.
মানে understand interim bail value is that. Interim হয় absolute হবে।
He will be there on 29th also.
Absolute হবে এটি না। Integrity কিয় লাগে আৰু?
Yes.
কিমান চলে? 53.
Next month.
53
Item number 9.
53 your lordship.
53 of.
21.
কোনটো?
Yes.
Petition ও তাইকো লৈ গ'ল। Petition তোমাৰ আগত।
Yes, lordship, this is the anticipatory bail, your lordship, and the page number 12 is the FIR.
Intent কৰি দিয়া। Movement.
What is the offense?
Offense is your lordship, the complainant, she has filed this lodged this FIR on 14/7/2024.
376. 376 IPC.
Lordship, there have not come 376, your lordship, because before lodged the FIR by the complainant, the petitioner has filed the lodged the FIR before the Sanmari PS on the page number 23. The petitioner is the well popular actor of the Assamese film industry,
Anticipated.
and he is facing some of the blackmailing from that lady, your lordship. She want to fulfill of her need from the petitioner, your lordship.
No,
And
what,
page number 23,
what is this 23?
page number 23, your lordship, the petitioner has lodged an FIR against the informant before the Sanmari police station, your lordship, on the dated 27/6/2024. I am the professional actor in Assamese industries and social influencer. I come from reputed family and strong financial background. So become the popularity profession. I have lots of friends, followers. A girl named Nomita Dotto, she comes to my life as a friend followers. She started making the trap and usually meet me for making me of her boyfriend. That I beg to state that became successful for her Malaphaidi intention plans to make me into the relationship. While coming into the relationship, I get to know that she only comes into my life for my money, for her luxurious lifestyle. After some time, she started blackmailing, taking money from me and threatening me that she will ruin my life if I will not fulfilling her luxurious lifestyle demands. I kept on tolerating, but she never understood. I wanted to marry her from her, but her threats, fights, and blackmail has made me so afraid of her, and for that reason, I break up with her. After breaking, I beg to concentrate of my profession, and normally my life goes on. But after 2-3 months of breakup, she again comes to me for ruin my life, as she has lots of my private photos with her. She had made fake social media accounts and uploaded my private photos for defaming my reputation and goodwill into the society. She fights, threatens, and demanded me for giving the huge money amount. But when I refused to give money to the girl, she uploaded my private photos and gone to my house while I was not there in my home. She had taken the advantage of my absence. She broke up the lock of my house and entered my house and burns the clothes of me and took all of my important documents. She had made my life hell and ruin. There is no way to come over the matter, and for that reason, I lodge an FIR against her because she is mentally torturing to me and make some of the false account in my name in different kind of social media like Instagram, Facebook, YouTube, etc., which I enclose below, your lordship. On the page number 25, she has opened one fake Instagram accounts against the petitioner, your lordship, and she defaming to him and demanding to money again and again, and he has lodged an FIR on 27/6/2024. After lodging the FIR, she has lodged this FIR before the Omen police station on 14/7/2024. Later on 20-25 days, your lordship.
Voter measure and present that FIR lost by the petitioner, that is a GD entry is there, my lord. So far, register hone niki GD entry হয়েছে.
GD and the police has
GD
not taken
entry
any action.
Yes, that is there on top of the that petition, my lord.
Where? Page number?
Yes.
Page number 23. Page number
Yes.
23. And
Uh,
your lordship, she has lodged an FIR 14/7/2024, and here she has mentioned all the about the history of the story making by her. That 2021, on the 9th July 2021, I'm pregnant with Siddhant Sai. 9 July 2021, and the FIR is 14/7/2024. Then how come 376 come, your lordship? Without any fair investigation, the Omen police has registered this case against the Siddhant Kolita, your lordship. And he is the well popular.
Heard Miss A. Medhi, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 482 of the BNSS, 2023 has been filed by the petitioner Shri Siddhanta Kolita, who is apprehending his arrest in connection with all women police station case number 40/2024 under section 406/376 within bracket 2 within bracket small n /323/313/506 of the Indian Penal Code. The gist of accusation in this case is that on 14/7/2024, the victim girl lodged an FIR before the officer in charge of all women police station, Pan Bajar, inter alia, alleging that the victim had relationship with the above named petitioner since September 2013. However, there was lack of trust between both of them. And in the affair, which is a long affair, several allegations were made against the present petitioner, including the allegation of deceitful physical relationship by the present petitioner with the victim girl on 9 July 2021, as well as an act of assault, attempted assault on the informant on 14 July 2024. 14 June 2024. Stop. Learned counsel for the petitioner has submitted that the allegations leveled against the present petitioner in the FIR are not true. In fact, it is submitted that the informant slash victim entered into acquaintance with the present petitioner, and thereafter, when he broke up with the informant, she started blackmailing him, she started blackmailing the petitioner, making several allegations against him, and unable to bear the said harassment, the petitioner had lodged an FIR before the officer in charge of San Mari Police Station on 27/6/2024. And thereafter, after lodging of the FIR by the present petitioner, the informant lodged FIR, informant slash victim lodged FIR
14/7/2020.
against him on 14/7/2024, mentioning therein the incident which were allegedly occurred long before filing of the FIR. Learned counsel for the petitioner has submitted that the allegation of physical relationship has been made as made on it has been alleged in the FIR that the physical relationship with the victim girl was made by the petitioner on 9 July 2021. And what is your submission regarding this?
His lordship, this is completely false allegation.
Okay.
Yes.
And the FIR has been lodged after almost 3 years of the same incident, of the said incident, and learned counsel submits that the false allegation has been made against the petitioner only to harass him. Stop. On the other hand, Mr. B.B. Gogoi, learned additional public prosecutor, submits that perusal of the case diary would be necessary, hence call for the case diary. Fixing?
Lordship, interim may be allowed.
So my lord, short date, my lord.
Not short date.
Then my lord, August, 2nd of August.
Fixing 2nd of August for case diary. However, in the meanwhile, considering the fact that apparently it appears that the FIR by the victim girl has been lodged against the petitioner only after he had lodged the FIR against her on 27/6/2024. Stop. Moreover, the allegations leveled against the petitioner in the FIR pertains to the dates, pertains to the incident which allegedly occurred much earlier than filing of the FIR. Hence,
No.
stop. In view of above,
এতিয়া সেই hearing
during the period,
hearing মাতিব। Failure.
no, hence the petitioner, above named petitioner is directed to, hence in the meanwhile, the above named petitioner is directed to appear before the investigating officer of all women PS case number 40/2024 within a period of 10 days from the date of this order and cooperate with the investigating officer. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with all women PS case number 40 of 2024, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this case be listed again on 1st of
Second
2nd of
August.
August.
And the lady, she want to come forcefully enter of his life, your lordship. And she is the general and the petitioner is the actor.
You
your
want
lordship.
modification
Go
in
to
the
police
order.
station, not court. Go to police station.
Okay, lordship.
Number
Much
9,
obliged.
Court number 24.
Yeah.
Late pleasure also.
Yeah,
439 application number.
Number 24.
petition আছে নাই আমাৰ?
Nalag.
Offense is 18B NDPS Act, my lord. The two
Eight-
numbers of petition.
18
18B, my lord.
commercial quantity.
Commercial quantity. Contraband is, my lord, suspected opium. Petitioner number 2, my lord, he is a 75-year-old man. And both the petitioners are behind the bars since 7/6/2023. That is 13 months, 12 days as on today, my lord. The FIR, my lord, you will find at page 16.
Now, what is your ground?
My ground, my lord, the suspected opium was, my lord, recovered. I took a ground that, my lord, section 42 and 50 was not complied. And, my lord, the independent witnesses, my lord, they were not from the locality, were from in the place of occurrence, my lord. So from the FIR, my lord, it is reflected clearly, my lord, that the provisions of section 42 and 50 has not been complied with. And that is why my lordship was pleased to call for the PW 1, evidence of PW 1 from the court below, and that has come here, my lord. So,
Where have you mentioned the grounds?
my lordship,
Where have you mentioned the grounds?
grounds, my lordship will find at para 13, my lord. It starts from para 11, my lord.
Fifty will not, is not applicable in case of a bag.
Yes, my lord.
The-
But in this case, my lord, 2 persons were apprehended. One sling bag was recovered, and from that opium was alleged to have been recovered.
From whose possession?
From, my lord, the accused number 2, that is 75-year-old man, my lord. But with regard to,
So in his case, 50 is not applicable.
but my lord, in the, my lord, the statement of the PW 1, a new, my lord, aspect has come up.
No, that
That-
we cannot consider now.
50, my lord, because why I am submitting that one, my lord, opium was, my lord, it was, my lord, in the waist of the accused number 1. It was recovered from one gamucha, and it was, my lord, tied in his waist. So it was attached to his body, and that is why section 50 would be attracted in this particular case, my lord.
Okay.
And 42, my lord, the person, the officer who had conducted the search and seizure, he was a probationary officer, my lord, and my lord, he was without any authorization, my lord. That in the cross examination, it has come up, my lord. So my prayer, my lord, that this,
Which provision of 42 is violated?
my lord, the authorized, he has to be an authorized officer to conduct the search and recovery, my lord. Any such officer, being an officer superior in rank to a peon, sepoy or constable of the Department of Central Excise, Narcotics, Customs, Revenue Intelligence or any other department of central government, including paramilitary force or armed forces, as is empowered in this behalf by general or special order by the central government. Or any such officer, being an officer superior in rank to a peon, sepoy or constable of the revenue
No, but
branch.
there is a circular of Assam government
My lord.
which authorizes officer above the post of SI of
Okay.
police.
He was, my lord, he was a probationary officer at the time of incident.
No, probationary officer in
My
his
lord.
status, his designation may be. What was his designation?
I think it's SI, my lord.
SI.
SI.
So SI is authorized. There is a circular of the,
Of state police.
yes. State government circular is there as far as I don't know. Mr.
Yes,
Goswami has to find it out.
my,
There is a circular.
yes, and more than rank of the SI. Yes.
You find out, you find out. And whether, what is your submission? What is your submission?
My lord, regarding that, PW1, only my lord,
Robert.
PW1's evidence has been, my lord, called for, my lord. There, my lord.
No, as regards his submission that 42 and 50 were not complied with.
Is that has to be, my lord, I have to be checked from the record, my lord. At the time of search, at the time of seizure, what are the formalities they have observed, my lord. If whether it will 50 or 40, 50 will attract or not, my lord. There.
Because, my lord,
Because in all the cases, my lord, 50 will not attract, my lord.
which is why I'm submitting, my lord, section 50. In the chief, my lord, he has stated, I found one knot on the gamocha worn by accused Ranjit Theory on his waist, and therefore I recovered some amount of kani.
Okay, from. No, this you can also find out from the case diary, from
Yes.
where the recovery was made.
Yes.
If recovery was made from gamosa tied with his waist,
Yes.
then 50 would be applicable.
Then we.
That is why, my lord, on the last
Case diary
occasion,
may be called for, madam.
and the last occasion, my lord, the statement of PW1 was called for. And it has come, my lord, PW1 along with the cross-examination. And here, my lord, here
In section
categorically
50, whether
stated,
they are independent witnesses or not.
No, PW1 will not help you.
Lord.
The
He
other materials have to be gone through.
he has done the search and seizure, my lord.
Whether
No, madam,
Case
as
diary
case
is-
diary is not available. Case diary has.
case
to be-
diary would be necessary.
My lord, if that is, I don't know.
Heard Mr. B. Chetri, learned counsel for the petitioner.
MK Das, my lord.
Sorry,
My-
heard Mr. M.K. Das.
Says please.
Heard Mr. M.K. Das, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. Learned counsel for the petitioner submits that in this case, the prosecution side, there is a lapse of procedural requirement by the prosecution side in not following the mandate of Section 42 as well as Section 50 of the NDPS Act, which are mandatory in nature, and therefore the petitioners are entitled to get bail on that count. On the other hand, learned additional public prosecutor submits, considering the submissions made by the learned counsel for the petitioner, perusal of the scanned copy of the case diary of Sadia PS case number 126/23 would be necessary, and same is not available before the court. Stop. In view of submissions made by learned counsel for the petitioner, let the scanned copy of the case diary of
LCR, my lord, my whole LCR, my lord.
Scan copy of the case diary of Sadia PS case number 126/2023, as well as scan copy of the case record of NDPS case number 54/23 be called for from the court of learned. Where it is pending?
Yes.
Learned
Special Judge Tinsukia.
Special Judge Tinsukia. Registry to take steps for requisitioning the aforesaid scanned copies. Let this case be listed again on when should I fix?
After 2 weeks. my lord.
Let if let us give a fixed date
Yes, my lord.
after 2 weeks.
Fixed date after 2 weeks.
Let this case be listed again on
August first week. August first week.
seventh of August.
My lord. No. Deeply.
Matter number 10.
Of which
Right, please, your lordship. Lordship, my senior is on legs, lordship. Can be the matter take up at 2, lordship.
okay after Sunday at 2.
Item number 53.
And copy. Yes.
Yes, Lordship, earlier occasion, Lordship has already heard of land. Only my part is that day I was unable to go through the LCR. One of the accused has already granted bail by this honorable court. Now, Lordship has made a query whether the first query is that whether the courier, that is the truck vehicle which is used, that is the courier company, whether they have been made a party or in that particular part there is some kind of investigation there is or not. And the second part was there, Lordship, as because there is a lock in the vehicle and that was broken by after breaking that particular lock, the contrabands were recovered, Lordship. That part, Lordship, I have gone through the same. They tried to call the courier company. One part, only that line is there. I have flag marked that part. Other than that, no part is there. They say that we are unable to trace that person. So during the trial, he may be called as a witness. Only that part is there. Otherwise, Lordship, he is in the same footing with the earlier accused person.
Where is the earlier bail order?
It starts from page 41, my lord, annexus 7.
You are helper.
Helper.
Yes, he is the helper. Earlier he was the driver.
Heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Dinsang K. Sangma, alias Dinsang Sangma, who is detained behind the bars since 3/4/2023. For how many days?
It's my lord over 472 days.
Within bracket for last 472 days in connection with special NDPS case number 33/23 corresponding to Bajari Chera PS case number 76/23 under section 22C/25/29 of the NDPS Act, 1985. At page?
Bail order is at page 41, my lord.
The gist of accusation in this case is quote paragraph number 3 from page 42. Paragraph number 3 from page 42. Learned counsel for the petitioner has submitted that the above named petitioner is the helper who was engaged in the truck which was seized in connection with this case. He has also submitted that earlier the driver of the truck has already been granted bail by this court by order dated 11/1/2024, passed in bail application number 3785/2023. It is submitted by learned counsel for the petitioner that during checking of the seized vehicle, it was found that the body of the truck was locked with an orange color bolt seal lock of GATIKWE in capital, bearing lock number 262666191. The bolt sealed lock was broken to open the container of the body of the truck, and after breaking the seal lock, the container was checked, and during checking 10 numbers of packets containing codeine phosphate penicillin cough syrup were found inside the said truck. The said 10 numbers of bags contained 2,000 numbers of bottles of codeine phosphate penicillin cough syrup, and each bottle contained 100 ml quantity of cough syrup. Learned counsel for the petitioner has submitted that the petitioner was only the helper of the engaged in the seized vehicle, which was a container truck of GATIKWE in capital courier company, and the container of the said truck was bolt with sealed lock, which was opened only through which can be opened only through an authorized person, and the helper, that is the present petitioner, was unaware of the content of the container, and he was not authorized to either lock or open the container. Quote paragraph number 6 from page 43. Quote paragraph number 7 of 43. Page 6 and 7 from page number 43. On the other hand, learned additional public prosecutor, though opposed the grant of bail on the ground that the present case involves commercial quantity of contraband, and hence Section 37 of the NDPS Act comes into play. However, he fairly submits that in this case, only driver and helper were made the accused. And even during investigation, the original consignor or the consignee or the courier company
They said that they tried, Lordship.
Where-
One part is there in the. but,
were not made accused,
Yes, not made.
were not made accused.
Yes.
And the fact that I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record, including the scanned copy of the case record of NDPS case number 33/2023.
Question 36. 36.
Quote para number 10, 11, 12, 13 from page 44. 13, 14 from page 14 and 15. Amila, itu bail order আছে, huh? From there you can. The prayer is allowed. The petitioner is allowed to go on bail of rupees 30,000 with one surety. This you need not to write. It is already there.
Deeply obliged.
30,000 with one surety of life.
No.
Same conditions.
Obliged.
Item number 54.
Of which court?
Court number, item number 54 or court number 24?
Yes. This matter was heard yesterday.
Yes. What was the, I forgot.
Convenience, my lord, this short written recommendation.
No, what was the, refresh the memory? What was the,
The page 28, my lord.
no, what is your ground?
Ground, my lord, apart from interrogational statement of the co-accused, nothing against me. my lord.
Yes. Have you find
Yes,
out?
my lord, I have gone through the, my lord, elsewhere, that this is, my lord, OP stage, my lord, charge yet to be framed, my lord. Charge yet to be framed, and my lord, in the statement I have seen, my lord, 161, he was also part-time driver of that vehicle, my lord, where from those contrabands, my lord, seized. He was driver.
No, but he was not he was not present when
He
the-
should know, he is driving the vehicle, my lord, he should know what is there in his vehicle.
No, he was not driving the vehicle.
He was there driving that vehicle, my lord. Co-accused statement also.
Where it is mentioned that he, because he
elsewhere
was
yes,
not there.
elsewhere on.
When were you arrested?
I was arrested because my lord, pursuant to this honorable court's order, I surrendered before the
Yes.
learned trial.
He was not found in the
Found.
truck. Is there any allegation that he fled away at the time of seizure?
Yes, my lord, he was not arrested
us-
from the spot, my lord. Subsequently, he filed a petition before this honorable court, and this honorable director to appear before court below, my lord, then
No,
he
Mr.
was
Gogoi,
arrested.
my query is why he has been roped in this case? Why he has been brought in this case? On what basis? What
Yes,
is the
yes, he-
accusation against him?
Actually, he was there in the vehicle, my lord. He
Yes,
fled
where is-
away,
where
fled
is
away,
that?
fled away.
Where
Yes.
is that?
Yeah, that is, I am showing.
If he was there in the vehicle,
Alias, no? Yes, that he hired the vehicle, my lord. This is here.
what is your name?
My name is my lord Ali Azman.
Who is Rueluddin?
Rueluddin is, I don't know, my
Now you know
lord. My-
as a,
As per this, my
That
lord,
real
FIR, my lord.
statement, my lord.
My lord, kindly see, the Rueluddin possessed the contraband, ganja, my lord.
no, whether Ruel is the driver or
The real, yes. Real actual driver, my lord.
Ruel is the driver. He is carrying this contraband in his auto, my lord.
no, apart from this statement, what else is there?
At this stage, my lord, what will come, my lord, the investigation complete, just the file, search it, my lord,
No.
charge yet to be framed, my
No,
lord.
that is my question.
Yes,
During investigation,
yes,
apart from the statement of co-accused,
yes.
whether investigating authority could collect any other evidence
Probe will come at the time of my lord trial, my lord. I leave it to your lordship. If your lordship want to grant bail, then up to your lordship, my
No,
lord.
no,
My
Mr.
submission is that, my lord,
Mr.
charge
Gogoi.
had to be framed against this person.
You
my
are
lord.
not answering my queries.
Yes.
It is not a question of I want to grant bail or I don't want to grant bail. It is, the question is whether they are entitled to get bail under such circumstances or not. The material which you are showing is the statement of the co-accused only.
Yes, yes.
My query is, apart from the statement of the co-accused, is there any other material which investigating authority
Because
could
that
collect?
vehicle was hired by this person, my lord. That vehicle was hired by this person. This person fled away.
Where is that?
That royal statement says that he has hired, present petitioner has hired the vehicle.
No, apart from because his statement is not admissible. There is,
Then I leave it to lordship. Then I leave it to lordship. That is the material in the diary, my lord.
so
the
apart
record.
from
Yes.
his,
Yes, that is no other material. Right, Lord.
yes,
Charge yet to be framed.
So, my lord, my submission, my lord, apart from the statement of the co-accused, nothing against me. And the summon was issued, my lord. Accordingly, my lord, I approached before this honorable court. This honorable court directed me to appear before the learned trial court to file a bail application. Accordingly, my lord, I surrendered before the learned trial court, file a bail application. After perusing the bail application, I was sent to my lord jail hazard. So, my lord, my act and conduct and the considering the Tufan Singh judgment and the Pulla with Ahmed Arimutta judgment.
where is Tufan Singh's judgment?
Tufan Singh judgment, my lord. Yes. So,
Which para?
para 10, my lord. Para 10 of Pulla with judgment, my lord. May I read, my lord?
Apart from this statement, there is nothing.
No other material. Only he was there, my lord, with him, my lord. What material will collect by the this is not possible. Only this person was with him, that driver, Royal. You.
Heard Mr. H.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. In this application under section 4, under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Ali Amzad Ilyas Ali Azmal, who is detained behind the bars since 19/6/2024. in connection with special case number 35/2023 arising out of Bajari Chera PS case number 86/2023 under section 20B to C/25/29 of the NDPS Act, 1985. The gist of accusation in this case is that, where is the FIR?
FIR, my lord. This is page 13,
That on 12/4/2023, an FIR was lodged by one Ashish Mohanto, SI of Police of Kothaltoli Watch Post, before the officer in charge of Bajari Chera Police Station, inter alia, alleging that, inter alia stating that on receipt of an information through reliable sources, that a huge consignment of ganja was illegally transported from the side of Kurti village towards Chandrika by a Bajaj auto rickshaw bearing registration number AS 10AC 8213. A Naka checking was organized near Kurti village at National Highway number 208A on 12/4/2023. And accordingly, after some time, the aforesaid Bajaj auto rickshaw was intercepted and was directed to be stopped. However, the driver of the said auto rickshaw tried to flee away. Stop. The police chased the driver and ultimately apprehended him, who is found to be one Ruel Uddin alias Jahir Uddin. Stop. During search of the Bajaj auto rickshaw, which was seized in this case, total 41 packets of ganja wrapped in plastic tapes were recovered. On weighing of the seized ganja, the weight was found to be 191.005 kgs. On receipt of the said FIR, Bajari Chera PS case number 86/2023 was registered and investigation was initiated. Ultimately, on completion of the investigation, charge sheet was laid against two numbers of, where is the charge sheet?
Charge sheet, my lord, page 21.
Against two numbers of, how many accused persons in the charge sheet?
Accused person, my lord. Total two numbers, two was sent, my lord,
Including the petitioner.
including the petition.
Two numbers of accused persons, including the present petitioner. Stop. Learned counsel for the petitioner has submitted that the
My lord, I'm sorry, my lord, including the present petitioner, three numbers, total three, page 29.
including the present petitioner, three numbers of the present petitioner, namely Ali Azmal, was shown as an absconder in the charge sheet. Learned counsel for the petitioner has submitted that the charge sheet has been laid against the present petitioner without there being any basis for the same. The only basis on which the charge sheet has been laid against the present petitioner is the statement of the co-accused recorded under section 161 of the CRPC, 161 CRPC/67 of the NDPS Act, which is not admissible in evidence against the present petitioner. Learned counsel for the petitioner has also submitted that after coming to know about the charge sheet, the petitioner approached this court by filing a anticipatory bail application bearing number
Bearing number, my lord. B number 427/2024.
AB number 427/2024, which was disposed of
Disposed on 15/5/2024.
on 15/5/2024, wherein a direction was issued, wherein the petitioner was directed to approach the trial court. And accordingly, the petitioner surrendered before the trial court on
On 19/6.
19/6/2024 and prayed for bail before the trial court. However, the learned trial court rejected the prayer for bail, and since then, the petitioner is detained behind the bars. Learned counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case by the co-accused, and the investigating authority officer could not collect any material during the investigation except the statement of the co-accused recorded under section 67 of the NDPS Act, which he submits is not admissible in evidence in a trial of an offense under NDPS Act, 1985. To support his submissions, learned counsel for this petitioner has cited following rulings. Number 1, Tufan Singh versus State of Tamil Nadu, reported in 2021 4 SCC page 1. Number 2, Narcotic Control Bureau versus Pallulabid Ahmed Arimutta, reported in 2022 12 SCC 633. I have, on the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the present petitioner, as on the ground that the contraband seized in this case is of commercial quantity, and therefore the embargo of section 37 of the NDPS Act is applicable to this case. He also submits that it is the present petitioner who hired the auto rickshaw which was seized in this case for carrying the seized contraband, as reflected from the statement of the co-accused Ruel Uddin, which was recorded during the course of investigation. However, learned additional public prosecutor fairly submits that apart from the statement of the co-accused, there is no other material on record against the present petitioner, and this truthfulness of the statement could only be ascertained according to him during the trial. And as the case is pending at the stage of copy stage only, he has opposed the grant of bail to the present petitioner. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the scanned copy of the case record of special NDPS case number 35/2023, which was requisitioned in connection with this case. It is apparent from record that though the charge sheet has been laid against the present petitioner along with two other co-accused for under section 20B2C/25/29 of the NDPS Act 1985. However, apart from the statement of the co-accused Ruel Uddin, there is no other evidence on record against the present petitioner. And in view of the judgment of the apex court in the case of Tufan Singh versus State of Tamil Nadu within bracket Supra, it is no longer res integra that a confessional statement recorded under section 67 of the NDPS Act, 1985 will remain inadmissible in trial of an offense under the NDPS Act 1985. And therefore, there appears to be no admissible evidence against the present petitioner on record to justify his detention and to invoke the embargo of section 37 of the NDPS Act 1985 against him in this case. This court is therefore of the view that in absence of any admissible evidence on record against the present petitioner, the petitioner is entitled to get bail in this case. Accordingly, the petitioner, above named petitioner, is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to satisfaction of the learned Sessions Judge. Which court?
Learned Session Judge, Malad Karimganj.
Learned Special Judge Karimganj, with following conditions. There are some conditions, you take it from Anita. Conditions. It is hereby made clear that the observations made herein before in this order has been made only for the purpose of consideration of the instant bail application, and this shall have no implications or bearing on the trial court while during the trial of the special NDPS case number 35/2023. With above observation, this bail application is accordingly disposed of.
God bless you.
I am taking a short break of 1 minute.
By the Boisista police in connection with Boisista PS case number 47423 on 9/8/2023. Since that the accused person has been in jail.
When were you arrested?
9/8/2023. Today's 345 days.
What is the offense?
302, 364A and 201.
Whether investigation is complete.
Investigation is complete and the case is pending at the additional session judge number 3 at the case is at the evidence stage. Although in this case, evidence started 3/1/2024, but till now, no witness turned up to give their testimony into this case.
No,
Therefore-
why the trial court rejected your bail?
On the ground that accused may flee from the.
Where is the rejection order?
And it's currently
At which page?
13.
13, Your Lordship. And
What is your name? Nitesh.
Nitesh Kumar, victim's name is Nitesh Kumar.
What is your name?
Abhishek Bulwa, Your Lord.
Abhishek.
Bulwa.
This is a case of kidnapping and murder.
Your Lordship, as per the CMB postmortem report, the victim was 17 years at the time of the incident. And section 360 clearly says that he should have to be 16 years. Kidnapping from local custody guardian.
No. Yes, Mr. Gogoi.
My lord, now charge frame against him, my lord. Under
When the charge was framed?
364 A
And
and
30.
302.
How he was killed?
Your Lordship, entire case is based on circumstantial evidence. No one has seen him committing the crime.
No, but how he was killed?
That postmortem report is saying something.
Postmortem report says something.
What it says?
আছে না আপনাদের?
This is, I think, not a case of grant of bail at
Yes,
this, at the-
normal case, my lord.
no, not at this stage, because the nature of committing murder. And thereafter, you again went to the petitioner, the victim's house to demand money. So at least some witnesses have to be examined, main witnesses have to be examined.
No, Lordship, all the witnesses are from our locality within Guwahati, but no, till now, no one is turning up.
When the charges were framed?
Charges framed on 5/11/2020.
Yes, Mr. Gogoi, what is your?
So I have objection, my lord, because materialists they are against this person, my lord.
Yes,
That he has kidnapped the boy, my lord. Thereafter he killed that boy, my lord. So everything is against him.
no, not before some evidence is collected, examined. Heard, Mr. What is your name?
Your name,
Yeah,
আপনার নামটা?
Ashok Kumar Dev.
Heard, Mr. Ashok Kumar De, Learned Counsel for
I
the.
beg your pardon, Your Lordship. Allow me to say something little more. The entire case is created in a concocted way, which is apparent from the fact that in the Caesar list, because I have not annexed either, they have said that I see you, Investor Dahal of Bashir Studios, do you have, I says the below described item on being led and shown by the accused Abhishek Burwa, son of Leela, which was kept in the, concealed in the dense jungle nearby a stream.
Thereafter, in the charge sheet, again the same police officer saying that on reaching the at Abjal Gonda forest, the sword with which he killed the Nitesh Kumar was recovered from underwater in a stream as shown by the accused. There are innumerable contradictions in the charge sheet and the seizure. There are many other things. How can it be possible two versions submitted by the same IO who is investigating the case? And another fact I like to draw your kind attention in this regard here. Some small dry branches of tree with bloodstain was recovered, was seized on being produced by Joyprakash Kaur,
No,
who
not,
was a
now,
shop owner
not now,
at 6 Mile.
not now. Because there are materials. Heard Mr. A.K. Day, learned counsel for the petitioner. Also heard Mr. D.B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure has been filed. Criminal Procedure, 1973 has been filed by the petitioner, namely Abhishek Barua, who has been detained behind the bars since when?
When,
Date of arrest?
9/8/23.
Since 9/8/2023. In connection with
Title page of apani likhibo lage, likha নাই।
Sessions case
page of
number
লিখিব লাগে।
231/2023
ঠিক আছে।
arising out of Bashishta PS case number 474/2023 under section 364A/302/201 of the Indian Penal Code. Learned counsel for the petitioner has submitted that in this case, the petitioner is facing trial in Sessions case number 231/2023 on accusation of committing murder of a 17-year-old boy, namely Nitesh Kumar. Learned counsel for the petitioner has also submitted that though the charges under section 364A/302/301 of the Indian Penal Code were framed against the present petitioner on 5/11/2023. However, even after lapse of more than 8 months of the said date, not even a single witness has been examined till date. Learned counsel for the petitioner has also submitted that the case against the present petitioner is based only on circumstantial evidence, and there are material contradictions in the evidence collected against him. Learned counsel for the petitioner has submitted that the petitioner is ready and willing to cooperate in his trial, and therefore he prays for allowing him to go on bail. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the present petitioner on the ground of the serious nature of the offense involved in this case, he submits that the manner in which murder of the deceased was committed in this case is itself reprehensible. No, manner in this committed itself goes against the prayer for bail of the present petitioner at this stage. What else is your submission?
My lord, from the FIR itself, my lord, saying that he has kidnapped that boy and killed brutally, my lord. Taking
Learned
his
additional
neck.
public prosecutor also submits that the brutal nature of the mode of committing offense by allegedly by the present petitioner also goes against granting of bail to the petitioner at this stage. I have considered the submissions made by learned counsels for both the sides and have perused the material available on record. It appeared that the allegation against the present petitioner is that he killed the deceased Nitesh Kumar by hacking him with a sword and thereafter covered the dead body with tree branches and the leaves and returned home and changed his clothes, took bath, and thereafter again went to the market and purchased a mobile handset. And from that phone, he called the father of the deceased and demanded 7 lakhs, threatening him of dire consequences. It also appears that the application for bail filed by the present petitioner before the learned trial court has been rejected by the trial court by its order 20/12/2023, considering the nature and gravity of the offense and the grotesque manner in which the offense was committed. This court does not wishes to differ itself from the observation made by the trial court while rejecting the bail of the present petitioner. However, it is also a matter of concern that since last 8 months after framing of charges, not even a single witness has been examined. Stop. The trial court shall make all endeavor to examine the listed witness as early as possible. Stop. However, considering the nature and gravity of the offense and the manner in which the offense is alleged to have been committed and the materials available against the petitioner on record, this court is not inclined to grant bail to him at this stage. Accordingly, the prayer for bail is rejected.
Item number 18. Item number 21.
May please, your lordship. Lordship, the accused is in custody, your lordship, 44 days. And the FIR is page number 8. Most respectfully, it is submitted that the few days back I came into
It
contact.
is there.
CD recipes.
Which one?
17/9, that's 17/9.
Page number 8 is FIR.
Yes.
They have a love affair, your lordship.
What is the allegation? Okay.
This month,
Allegations 419,
and busy as well,
387,
preliminaries.
506 of 36. And these sections are not applicable against the petitioner, your lordship. He is completely innocent and he is love affair with the informant.
If you have love affair, then why you are demanding money?
Not demanding money, your lordship.
But that is the allegation. You have made the video
No, Lordship.
clips viral.
Allegations are completely false, your lordship. I have no any demanded by me, your lordship, money to her. But she has helped to me in a financial condition. Because my financial condition is not so good. And after then, when she break up with me, then I have already returned back all the money to her.
Yes, Mr. Gogoi.
Yes, my lord, his 161 statement, he has admitted something, my lord. He took some money, my lord, there. After he is saying that he has returned, as he introduced himself as doctor. So they come to close relation. That is,
And what victim says?
victim says, my lord, yes, he has threatened also, my lord, that is there.
What is the progress of the investigation?
Obvious, my lord, that recorded the statement of both and some witnesses also, my lord. That is there, my lord.
Heard Ms. A. Medhi, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure from 1973 has been filed by the petitioner, Shri Dijul Soikia, alias Nipu Soikia, who has been detained behind the bars since 6/6/2024, within bracket for last 44 days, in connection with Basishto PS case number 411/2024 under section 419/420/387/506 of the Indian Penal Code. The gist of accusation in this case is that the victim girl lodged an FIR on 6/6/2024 before the officer in charge of Basishto Police Station, inter alia, alleging that she came into contact with the present petitioner through Facebook and a relationship started between them, and the petitioner assured to marry the informant. It is also alleged in the FIR that though the present petitioner introduced himself to be an MBBS doctor, but actually he is not so. It is alleged in the FIR that the petitioner threatened the victim girl to make viral the video clips of intimate moments of the petitioner and the victim girl in social media and demanded money on that basis from the informant. And accordingly, informant paid the petitioner an amount of rupees 1,50,000. There are other allegations made in the FIR, including the threatening to kill by the petitioner made to the informant. Stop. Learned counsel for the petitioner has submitted that the allegations leveled against the petitioner in the affair are not true. She submits that there was in fact a romantic relationship between the petitioner and the victim girl, and when there was a breakup between them, the victim lodged the false FIR against him. She also submits that the petitioner, while in financial need of money, took some money from the victim girl, which he had already returned. Learned counsel for the petitioner also submits that, considering the period of detention already undergone by the petitioner, he may be allowed to go on bail. On the other hand, learned additional public prosecutor submits that though there are some incriminating materials against the petitioner in the case diary, however, the investigating officer has recorded the statement of relevant witnesses, including the victim girl as well as the petitioner, and the investigation has fairly progressed. Considering the submissions made by learned counsel for both the sides, and also considering the materials available on record, including the case diary of Boshishta PS case number 411/24, as well as considering the period of detention within bracket 44 days already undergone by the petitioner, this court is of considered opinion that further custodial detention of the above named petitioner may not be necessary for fair completion of the investigation of Boshishta PS case number 4111/2024 if he cooperates with the investigating officer. Stop. In view of above, the above named petitioner is allowed to go on bail of ₹30,000 with one surety of like amount to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions. Condition number 1 and 2. Send back the case diary. This bail application is accordingly disposed of.
Case number 11, court number 24.
Code 24.
May I believe, Lordship? Lordship, in this case, interim is there, Lordship. I have appeared and statement has been reported.
What is your name?
Interim আছে না?
Item 11 of court number 20. Third, Mr. What is your name?
S.J. Sohoria.
S.J.
Sohoria, Lordship.
Sohoria, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was allowed to go on interim anticipatory bail by this court on 18/3/2024 with certain conditions, and accordingly he has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Boshishta PS case number 131/2024 and has submitted that he has appeared,
Yes, my lord.
that
Statement
the
record.
petitioner has appeared before the investigating officer, and his statement under section 161 CRPC has also been recorded. So in view of the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to the above named petitioner on 18/3/2024 by this court is hereby made absolute, with condition number 1 and 2 attached to the said order remaining intact. This bail application is accordingly disposed of.
Deep level.
Case number 21, court number 21.
CD was called for investment.
Item number?
Here, diary not received, my lord.
You are on interim.
Yes, yes.
You are on interim.
Yes, sir.
What is your name?
R. Alam Lordship on behalf of SO.
What is your name?
R. Alam on behalf of SO.
Heard Mr. R. Alam, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who submits that some more time is required for producing the case diary. The prayer is allowed. Let this case be listed again on
5th of August.
5th of August. The interim order shall continue till next day.
Applies this.
Item number 22.
Yes.
By case, no, it will be like it.
Case diary?
Yeah, here, my lord, charge it submitted, my lord.
Interim is there, Lordship.
You appeared before the IO.
Lordship.
Have you appeared?
Appeared.
When?
That is not.
Date,
But appeared, Lordship, and then subsequently his statement already been recorded.
Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
433/24, dated 17/2/24.
On the other hand, learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by this court on 2/2/2024 with certain conditions. And in pursuant to the directions of this court, the petitioner has appeared before the trial, before the investigating officer, and has cooperated in the investigation. In view of the submissions made by learned counsel for the petitioner, the interim order dated interim bail granted to the above named petitioner on 2/2/24 by this court is hereby made absolute with condition number 2 and 3 attached to the said order remaining intact. This anticipatory bail application.
Item 23.
None appears for petitioner on call. Case diary is there.
This charge sheet submitted, my lord, here.
On the other hand, Mr. B.B. Gogoi, learned additional public prosecutor, submits that in the meanwhile, what will happen to the interim bail?
Interim, that we have no instruction, only they says that charge is submitted.
Let us fix it
Some other. day.
some other
Yes,
day.
yes.
On the other hand, learned additional public prosecutor submits that charge sheet has been submitted bearing charge sheet number
Charge sheet number 95/24, dated 31/5/24.
Let this case be listed again on 24/7/2024.
May I please your lordship? For 38 application, my lord. But what happened, this petitioner was charge sheeted showing him absconded. In fact, the case relates to the death of his sister-in-law, and his brother is the main accused man. And they suspected that he was killed, but she died she had a normal death manner. Anyway, my charge sheet has been filed. Your lordship is aware of the decision of our own High Court that charge sheet cannot be filed as showing him absconded without following the CRPC's provision 87. Now, here, my lord, and when after charge sheet also, there is no bar to consider the bail matter. Now, I am willing to appear to the court in this, and to face the trial also along with my other brothers.
But,
Kindly allow me to go, my.
but the bail will be considered by that court.
My lord, your lordship, give me protection, then I will appear.
Till then, I will give you
Yes,
protection.
Till then, proper. Because there are judgments of our own High Court. And your lordship also granted bail in so many cases.
No, but that is 482 petition.
Beg your pardon?
Against you, what process has been issued? Non-bailable warrant of arrest.
Nothing of that, sir. Nothing of that. I make the, well, Supreme Court says that in Sandeep Kumar, Bafna, as well as the Dataram, that there is a apprehension that if he appears that there is a likelihood of his bail may be not be considered. But it is of no use of detaining him inside the jail and to have his trial.
No, but you may threaten witnesses.
Beg your pardon?
You may threaten witnesses.
Nothing,
Because
I will
this-
take that. Why should I threaten? Other
Because
actions there. I
this
am
is
not
a
a very
30
active married. My brother, who is married, the lady, he is the main accused married.
Then we will grant interim anticipatory bail till your appearance.
But I am facing the other judgment also. Our own High Court has granted.
But
In a 307, 302.
in AB case,
Yes.
Absolute bill.
No. Direction to appear,
That is
direction to appear to consider the bail.
repeatedly to
And
exceed.
protection has been given. Ma'am.
That is
show me,
Yes,
show me.
so.
yes. It is our own High Court matter. Then when Bharat Chaudhary's case matter, I have already marked. Then Sandeep Kumar's Bafna's case matter, Supreme Court. I have underlined this matter. There are 26, 27. Then Dataram's case matter. 17.
No, regarding power of the court, I am not in doubt. Power is there,
Yes,
but these facts we are not aware. The trial court is the best judge to grant bail during
My lord,
the pendency of trial.
in the Dataram's case, the court said that the direction was given to the court to consider his bail. I have marked the green mark I have given.
That case was under what section?
302. And the more heinous crimes are also involved in other cases.
Where is the FIR?
FIR is in my lord. Page, my lord, page 11 is the FIR.
What is the allegation?
Allegation is that it is respect to page 15, I am reading, my lord. It is respect to submitted the above mentioned affidavit number 1, that is my brother, my lord. Since the last few months, my sister's husband has been mentally torturing my sister Hamida Begum and is demanding money from her. Earlier, the villagers have settled the matters along with, among the other many other.
What is the allegation against you in the
I
charge
am
sheet?
family members.
No, in the charge sheet.
I am belongs to same brothers family. They said that we have connivement in the death.
Where is the charge sheet? You have not annexed the
No,
charge.
no, it came to later on, but it has come, this scan copy has also come.
Scan copy of this case, record on logot থাকিব।
Another aspect is also to consider that one cannot be shown as absconder, shown him absconder without following the due process of law.
No, therefore I was asking what process the court has issued. If the trial court has issued only summons,
No, yes, someone is. Someone, yes. But someone is there also Supreme Court discussed that there is a because it's a non-bailable offense, when I appear, I will be sent to the jail.
I agree that even if summons are issued, if committal court may not grant you bail,
Yes.
in
Before your occasion.
in an appropriate case, you may be granted bail.
But
but-
what is
but
appropriate, what is
that
not
will-
appropriate?
That I am saying,
Yes.
what I want.
Yes.
What materials are, suppose you are the main accused, the manner in your participation in the crime is apparent, then you may not be granted bail. Suppose what materials are there against you in the charge sheet, that is relevant, which you have not pointed out. Therefore, I am asking, what are the materials against you?
That, everything before your lordship in a scan copy.
No, but you have to assist me.
But to me, I am innocent because if anything has been done by my brother, if any torture was done by my brother, whose wife has been killed or died. And medical report is also, postmortem is also there in the scan copy. The first and foremost thing is that I am going to appear and I want to face the trial. Whatever, if I am convicted, I will go to the jail, my lord. I will remain inside the jail.
Who is the husband of the victim girl?
Husband of the victim guard is my lord. Saibuddin. Entire family has been made accused, my lord. My all brothers, sisters. Any condition, my lord, I will face the trial, I will appear regularly. I will not interfere with the trial also.
Heard Mr. S.C. Bishwas, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Abbas Uddin, who is apprehending his arrest in connection with what is the case number?
Badarpur PS case number.
You are not apprehending arrest in PS case number. You are apprehending arrest in PRC case
Yes.
after submission of charge sheet. What is the number?
Badarpur PS case number 146 2023.
PS case is not relevant.
Number charge sheet to point.
When have you filed this Anticipatory bail application after filing of charge sheet.
Yes, when someone came.
Someone came. Then you must be knowing the case number of the PRC case number. That has to be mentioned.
Someone to assign, not to assign.
Someone is not with me.
Because someone cannot come with PS case number.
Someone is not with me, my lord.
Then why should I believe you? In connection with PRC case number 308/2024 corresponding to Karimganj PS
No, it
case.
is Badarpur, my lord. It has been corrected, my lord, subsequently. Badarpur, case number is same, Badarpur.
Badarpur PS case number 146/2023. Learned counsel for the petitioner has submitted that the petitioner has, though the petitioner has received summons from the learned committal court. However, as the case against him and how many other accused persons?
6 men.
6 other accused. Total how many number? What is the number of accused persons?
Total, my lord, total 8 men. 8%.
8 accused persons. Charge sheet has been laid against
Yes.
against the present petitioner and 7 other accused persons under section
302.
302 slash
120B, 302.
120B of the Indian Penal Code, and hence the embargo of section 437(1) within bracket small Roman 1 would come into play, and the court of a judicial magistrate first class may not grant bail in this case, as the punishment prescribed for 302 is up to death penalty. And therefore he apprehends that even if he appears before the committal court in compliance with the summons received by him, he may be remanded to custody.
Yes.
Stop. Learned counsel for the petitioner has submitted that in this case, the allegations leveled against the present petitioner are not true, and he has been implicated and roped in the case only because he happens to be the
Family member.
brother of the
Brother of the
husband of the deceased. It is also submitted that the petitioner is ready to face trial and his custodial detention is not necessary for fair completion of the trial. Mr. Gogoi, what is your submission?
Case of 302, serious nature, my
You are
lord.
opposing.
Opposing, yes.
On the other hand, learned additional public prosecutor has opposed the grant of bail to the petitioner on the ground that the case involves offense of serious nature under section 302. Stop. I have considered the submissions made by learned counsel for the rival parties and gone through the scanned copy of the case record which was requisitioned in connection with this case. It appears from materials available on record that though the though the charge sheet has been laid against the present petitioner also, however, specific allegations were leveled against one Siab Uddin, who is the husband of the deceased and the brother of the present petitioner. And brother of the present petitioner. It also appears that though the present petitioner has received summons from the court of learned judicial magistrate first class Karimganj, which is the committal court where presently the PRC case number so and so is pending, or is pending. However, as offense under section 302 is involved in this case, it may happen that even if petitioner appears in compliance to the summons received by him before the said court may not grant bail to him due to embargo of section 437 within bracket 1 within bracket small Roman 1, and the court may remand him to custody on his appearance due to such embargo. This court is of considered opinion that custodial detention of the present petitioner is not necessary may not be necessary if he cooperates in the trial and does not indulge in threatening any of the listed witnesses. In view of above, this anticipatory bail application is disposed of with a direction that the petitioner shall appear before, what is the next date?
Within 10 days, I will appear.
Shall appear before the committal court within 15 days from the date of this order. And on his appearance, the said court shall grant him bail of rupees 30,000 with one surety of like amount subject to the satisfaction of the said court with following conditions. He will cooperate in trial, shall not threaten the witnesses, and shall abide by these conditions. With above observation, this anticipatory bail application is disposed of. A judgment will occur. None appears for the petitioner on call. List this matter again on 24/7/2026.
May I please, your lordship? The exhibit is the same as in item number 24, your lordship adjustment. The FIR was lodged in 2002, your lordship, and so one. I have not been named in the FIR. Charge sheet has already been submitted, your lordship, on 29/5/2007, long back, your lordship. So further custodial interrogation of the petitioner is not necessary, your lordship. And I have also annexed the judgment of some coordinate benches as well as your lordship has just now passed in item number 24, your lordship. Is a session triable case 302. So till
What is
committal, I
the
may.
allegation against you?
Allegation, nothing. There was a group clash between two groups in a cinema hall in 2002, your lordship. Subsequently, there was a mutual understanding, but later on, there was a scuffle.
Where is the FIR?
FIR is Annex 1, page 13, your lordship.
Okay, tell me the facts. What happened?
May I read your lordship?
No need to read it. You may tell the gist. What
So
happened?
subsequently, there was a clash and the son of the complainant later on got injured and later on succumbed to the injury after 2-3 days, Your Lordship. Thereafter, it is of 2002. Then charge sheet was submitted in 2007 against 5 number of accused, Your Lordship,
including you.
including, though my name is not exactly the same, myself is Shahjahan Ahmed Mojumdar. In the charge sheet, it was named as Shahjahan Ali. Shahjahan Ali.
Then why are you appearing?
The police are visiting me, my house, Your Lordship. That's why I'm apprehending, Your Lordship. So I will face the trial, Your Lordship. I will support in the investigation.
No, if you are not the person, why will you face the trial?
Because police has already, I have categorically stated, the police visited my house on 25/4/2024.
Whether you have another name, you have also a alias name.
That's why, whatever may be, I will face the trial, Your Lordship.
No, you have to at least make fair submission before the
Yes, I am
court.
making a fair submission.
Whether you are also Shahjahan Ali,
No,
you are not known as
No.
Shahjahan Ali.
no.
Then
Ma-
why are you afraid?
Because the police has searched me. They came to my house on 25/4/2024. In para 4, I have categorically stated, page 5. Page 5.
Now, what will you say before the trial court? That though I am not Shahjahan Ali, but I am ready to face trial.
Yes.
No, I am not understanding your plea. You are saying you are not Shahjahan Ali. Charge sheet has been laid against Shahjahan
Ali.
Ali. You are Mr.
Mojumdar.
I am Shahjahan Ahmed Mojumdar.
Only because police is searching you.
Police is searching me and subsequently summon was also issued, Your Lordship. The name is first,
Where
Your
is
Lordship.
the summons?
Summons, Your Lordship may kindly see the order.
Page number?
Page 27, annex of 4. Annex of 4. Below portion, accused person, namely Shahjahan Ali, was shown as absconder. Next, annex of 5, page 29. Issue fresh NBWA against the accused named Shahjahan Ahmed Mojumdar.
Okay.
You are Shahjahan.
I am Shahjahan Ahmed Mojumdar.
So though your name is not there in the charge sheet, however, court has issued
Yes.
non-bailable warrant
Yes,
against.
Your Lordship, I am apprehending. I will appear before the court. I will face the trial, Your Lordship, if necessary.
Still you will face the trial.
Now, first I will appear before if Your Lordship granted me the privilege, I will definitely appear before the SDJM Sadar, Your Lordship.
No, I am not understanding. If you are not Shahjahan Ali, why will you face the trial?
Because
Court has mistakenly named you, issued warrant against you.
that's why I am apprehending.
Therefore, you will face the trial. That is the submission.
After this order, police is searching me.
No, that is okay. But you are also saying that you will face the trial.
What I am at this moment, Your Lordship, after passing of this order on 12/12/2023, police visited my house on
No,
25/4.
that I have understood. Yes, Mr. Gogoi.
Yes, sir. In the record, my lord, I have flag mark, my lord. One person identified him, my lord, as Shahjahan. Shahjahan বুলি কৈছে Ahmed Mojumdar ইমান details নাই.
Okay.
That is
So
Shahjahan.
that plea he can take before the trial court.
Yes.
If he is eager to face trial, let him face trial. But because he heard Mr. R. Majumdar, learned counsel for the petitioner, also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Shahjahan
Ahmed Mojumdar.
You have not named your mention your name properly in the bail application. Ahmed is not there.
First page of আপনার আহমেদ নাই লেখা।
No, no, my name is Sajan Mujumdar.
Are you sure?
Yes, yes.
Now we are submitting that Ahmed Mazumdar.
Because you are making submissions before the court. At least submissions have to be fair.
Petition কথা বলছি।
এইবিলাক বাদ দিয়ক, আপনি submission দিওঁতে
Your Lordship, my marksheet, HSC marksheet of Sajan Mujumdar, not Ahmed.
Then why are you saying Ahmed Majumdar?
No, no, NBWA was issued against Sajan Ahmed Mujumdar.
Okay.
I'm sorry. Your
So NBWA are also not issued against your name.
Middle name is missing. Sajan Mujumdar is there.
Shah Jahan Majumdar, who is apprehending his arrest in connection with
Connection with Silchar PS case number,
no PRC case number
PRC case number 2136,
PRC case number 2136
2020,
2020 corresponding to Silchar PS case number 1157 202 2002 under section 147/148/149/326/302 of the Indian Penal Code. Learned counsel for the petitioner has submitted that though on the basis of an FIR which was lodged in the year 2005,
27/08/2002, FIR.
2002, and on the basis of which Silchar PS case number 1157/2002 was registered, and ultimately on completion of charge sheet, the investigation charge sheet was laid, wherein laid against
Sajan Ali, including 4 others.
against 5 accused persons, including one Shah Jahan Ali, comma. However, learned counsel for the petitioner submits that the present petitioner is not the person against whom the charge sheet has been laid and whose name has been mentioned as Shah Jahan Ali. What is your father's name?
My father name is late Haji Mahmood Ali Mujumdar.
So father's name is Tally.
No, in the church, the father name is also different.
Oh.
Father name is, Your Lordship, Shahid Ali Haji Maud Ali. Haji Maud Ali, page 18.
Learned counsel for the petitioner submits that the committal court, that is the Court of Learned SDGM S. Kachar, before which the PRC case number 32136/2020 is presently pending, on 12/12/2023 had issued non-bailable warrant of arrest against one Shah Jahan Ahmed Majumdar, stop. Learned counsel for the petitioner has submitted that though the present petitioner is the name of the present petitioner is only Shah Jahan Majumdar and not Shah Jahan Ali or Shah Jahan Ahmed Majumdar. However, the police is now searching for him on the strength of the non-bailable warrant of arrest issued by the learned SDJM S. Kachar Silchar, and therefore he is apprehending his arrest in this case. Learned, on the other hand, learned additional public prosecutor has submitted that during investigation, the accused has been identified
By one
by
witness.
only by one witness, by only his first name, that is
Yes.
Shah Jahan.
Shahjahan, yes.
And apparently it appears that there is discrepancy in the name of accused shown in the charge sheet as well as in the warrant of arrest issued by the learned SDJMS Kachar Silchar on 12/12/2023 to fortify his submission regarding name of the present petitioner as Shahjahan Majumdar. The learned counsel for the petitioner has produced the copy of the high school living certificate as well as the PAN card of the petitioner wherein his name has been shown as Shahjahan Majumdar only. So, I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor and have gone through the materials available on record, including the scanned copy of the case record of PRC case number 2136/2023. It appears that the charge sheet in the PRC case number 2136/2023 has been laid against 5 accused persons, including one Shahjahan Ali. And it also appears that by order dated 12/12/2023, the Court of Learned SDJMS had issued warrant of arrest against one Shahjahan Ahmed Majumdar. So it also appears that the present petitioner is neither Shahjahan Ali nor Shahjahan Ahmed Majumdar, as appears from the high school living certificate as well as the PAN card produced by the petitioner in support of his submissions, produced by the counsel for the petitioner in support of his submission. However, as the police is searching for the present petitioner, there is a genuine apprehension that the petitioner may be apprehended on the strength of warrant of arrest issued against him by the Court of Learned SDJMS Kachar Silchar. In view of above, you appear before the trial court, make submission regarding discrepancies of your name, and take whatever plea you want to take there. In view of above, the petitioner, namely Shahjahan Ali, is hereby directed to appear before the Court of Learned SDJMS Kachar Silchar within a period of 10 days.
15 days, Your Lordship.
15 days from the date of this order, so that he may make an appropriate application before the said court, narrating his side of the story. To enable such appearance, however, in the meanwhile, if on the strength of the warrant of arrest issued by the said court, the above named petitioner is arrested, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority. Stop. On his appearance before the Court of Learned, SDGM S. Kachar Silchar, the above named petitioner may make prayer for appropriate relief before the said court, to which he may be legally entitled to. With above observation, this anticipatory bail application is disposed of.
গাড়ি আছে না নিজর? গাড়ি আছে না?
that up to date diary is not received today.
Actually, against the petitioner, nothing, my lord.
Victim not recovered, victim not recovered. That earlier diary shows.
Case diary would be required. Heard Mr.
Game over.
A. Mubarak, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed on when case diary
30th, my lord.
on 37/2020.
Lordship, hereafter, I will be out of state.
When
Then-
registered date,
5th of my lord.
5th of August.
Yes.
5th of August.
Possible.
Item number 28.
None appears for the petitioner on call.
Here, my lord, charges submitted, none appeared, but charges submitted.
Let this case be listed again on Monday. On 22nd.
May I please, Your Lordship? So this is 430 application. So may kindly peruse the last order. Certain injury reports were called for. And it has not come since last 3 dates, Lordship, from 14/6 till today.
What was the allegation?
Allegation of Lordship, the accused person has gone to the house of the informant and informant's house, and they broke in inside the house in night and attacked with dao.
Now,
Lordship, and the injury report which is received, as he had submitted earlier, of the wife of the informant. Allegation against that she was also injured. That's the reports are simple injury.
Main victim is a husband. Husband injury report is not available. My lord, wife injury report is here.
Lordship, kindly got FIR of March 2024. Lordship. Now in
why
July,
injury report is not coming?
and it's 4 dates.
That is, my lord, not mentioned here, only one.
No, you may speak to the IO
My lord,
that injury report of husband, why it is not coming.
Lordship, protect us. We have no interim also.
Mm.
Because they are.
No, but since March you are without interim.
Lordship,
You can wait for 1 week.
Lordship remembers the first day it was listed before your Lordship only. Lordship has also fixed it very early day. Lordship says 6/6 order, 6/6/2024 order. Then Lordship has pleased to fix it very early date on 14th of June. That day also the case diary came, the injury reports are not available.
What
continued.
injury is alleged?
He attacked with dao, Lordship. He had a cut in his leg and others. Lordship will see page number 10, Lordship. It says cut me with dao and also attacked me again. Also attacked my wife with dao, Lordship. And cut on her right leg with dao. But their injury report is simple injury. So
that is simple,
but
wife.
informant has written in the FI, she was cut with the dao. Yeah, what we submit, Lordship, it's a family dispute. He has filed a FI to avenge against the family members, other family members. And the FI.
Here there is a note, my lord. I have note. প্রকাশ থাকে যে মোতায়েন থানাত আহি উপস্থিত হৈ অৱগত কৰে যে বৰ্তমানলৈ মোকদ্দমাৰ গুচৰীয়া ও ভুক্তভোগী স্বাস্থ্য পৰীক্ষাৰ প্ৰতিবেদন হাজু নোহোৱাৰ বাবে কৰ্তৃপক্ষৰ পৰা স্বাস্থ্য পৰীক্ষা প্ৰতিবেদন পোৱা নগল। হাজু not ready, that means. গতিকে পৰৱৰ্তী সময়ত পুনৰ স্বাস্থ্য পৰীক্ষাৰ প্ৰতিবেদন সংগ্ৰহ কৰা যত্নমান থাকিল।
What is your submission?
Now, meantime, they may collect, my lord, this note is of 10/5/24. And diary is up to.
Then we are
12,
fixing a very short date. You find, we are fixing a very short date.
Yes.
It has been short dates all along, Lordship, but no injury report has come. Lordship sees the dates, it is on 6 first, then on 14, then again on 38, then 11, now 19.
No, we don't know what kind of injury he sustained.
Lordship, had the report been there, they would have sent it. Now, having a
Okay.
report.
No, we are giving a short date. Heard Mr. MP Goswami, learned,
Lordship D. Becker.
sorry, heard Mr. D. Dekar, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who submits that he may be granted some more time for producing the injury report, as there is an endorsement of the investigating officer in the case diary that injury report could not be collected as same has not been prepared by the concerned medical officer. Stop. The prayer of the additional public prosecutor is allowed. Suggested date,
Yes, my lord, orang, so. August. 1st of August.
1st August.
2 weeks, Lordship. Consider until then.
Let this case be listed again on 1st of August.
Lordship, endorsement date may be, Lordship, that's of May, so that will be reflected. Date, endorsement date of the CD is of May, that was submitted by.
Yes, that diary is not up
So
to date.
if that's May, it's 3 months, so that
That's
will
why
be reflected.
again and again we are calling for that report,
If
my lord, but
the
they-
prosecution side fails to produce the injury report on the next date fixed, the prayer for interim bail shall be considered on the next day.
Thank you, Lordship.
Number 30.
Actually, diary not received. Interim is there.
Their own interim. Both
Heard-
petitioner, my lord, mother and daughter.
Heard Mr. Ainuddin, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed again on
7-8.
7/8. The interim order shall continue till next date.
Item 31.
Here also diary not received, interim is there.
Same order.
Yes.
Date,
Yes, not looking for, yes, my lord,
Heard
7-8, no problem.
D made he, learned counsel for the petitioner. Baki eke order. Date, next date is
7-8.
7th of August.
August.
Interim shall continue till next day.
Item 32.
DK made.
32 diary not received, my lord, there is no interim, I think, no?
Yes.
Interim line. So sorted.
Learned additional public heard
J.I. Mundal.
J.I. Mandal, learned counsel for the petitioner. Learned additional public prosecutor, Mr. B.B. Gogoi, prays for some more time for producing the case diary as well as injury report. The prayer is allowed. Let this case be listed again on
2nd of August.
2nd of August.
Item 33.
May I please, your lordship, 438 application, lordship. Lordship, though the matter is sachet, lordship, it is something different, lordship. Lordship, the registration of the Mankasar police station case, lordship, it was totally ignorant. I was totally ignorant, lordship. Kindly see page 11 is the FIR, annexure 1.
LCS 1, I think, no? No, LCS.
A scan copy was called for, lordship, of PRC 235 of 2024, which is pending in the Honorable Court of CGM, South Salman, Mankasar, lordship. Scan copy available?
Skin ko kya hissa mein sua nahi, কিন্তু এই উল্টা পুল্টা হয়ে গেল গোটেই কেসবোৰ।
Now, what is your case?
Lordship, offences were registered under section 448, 376, 506 IPC, lordship. Lordship, so for the allegations of the FIR is concerned, lordship, I was trespassing the residence of the informant, lordship, and committed rape, lordship. And thereafter I was caught red-handed by the public, lordship, and thereafter I was handed over to the VDB secretary, lordship. Lordship, and the FIR, so for FIR is concerned, lordship, alleged date is 24/5/2018, and after 9 days, lordship, this FIR was lost, lordship. And also this fact, lordship, handing over the accused to the VDB secretary, and thereafter he could manage to flee away, is quite unbelievable, lordship. And lordship, and thereafter the matter was sachet, lordship, and when I received the summons from the learned committal court, lordship, I came to know that this case was registered against me, lordship. and next date, I was summoned, and the next date is 25th of September 2024, Lordship. And if I appear before the committal court, Lordship, definitely I will be put into the jail, Lordship.
But your conduct is not good. You first of all fled away.
Lordship, this is the allegation, Lordship. Even I
No,
don't
that
know.
allegation is sufficient because the allegation is of 376, which after charge sheet materials were found and charge sheet was laid.
Lordship, kindly.
So your conduct has to be inspiring to get.
Lordship, this allegation totally false allegation, Lordship. Kindly see medical report, Lordship. Annexure, medical report, annexure 3, Lordship.
Page.
Page. I'm coming, Lordship. Page, from 30, started from 30. Kindly see page, Lordship. D, Lordship, page 31, serial number 12, D. Report is normal, Lordship. There is no any report regarding committing of rape, Lordship.
No, the medical examination report is not everything because it was conducted after more than 10 days. So report would be obviously normal.
Lordship, FIR is also delayed, Lordship, 9 days, Lordship. There is no explanation, Lordship, and there is inordinate delay, Lordship, unexplained delay, Lordship, which is fatal to prosecution, Lordship. Whatever it may be, Lordship, I am ready to surrender before the learned court below, Lordship. Lordship, I am ready to face the proceeding, Lordship. So, Lordship, I am ready to appear on 25th of September 2024, Lordship. Therefore, Lordship, I am before a Lordship. Some sort of protection is required, Lordship. Otherwise, I will be put into the jail, Lordship, because it is a committal court, Lordship. And the sections 376 subsection 1 is this offense is triable by Court of Sessions, Lordship. And there is no any criminal antecedent, Lordship. And for last, police never visited my residence, Lordship. During last 5 years, Lordship, I never left my residence, Lordship. Police never visited my Lordship. Police never searched me, Lordship. And registration of the case of Lordship is totally, Lordship, out of my knowledge, Lordship.
Yes.
Lordship, he was shown as absconder, case of 2018. Now he is coming for my anticipatory bail.
No, he may come.
He may come, my lord.
He may come, but
his conduct
has to be good.
He should cooperate with.
The allegation against you is that you threaten the husband of the victim, that you will kill the husband of the victim if.
Lordship, it is the allegation of the affair.
That is enough at this stage.
It is the allegation, Lordship. Lordship, even Lordship, if it is so, Lordship, police would have searched me, Lordship, but he never searched me, Lordship. And I didn't know that even a case has
When you received the summons?
Lordship, whatever it may be, summons, Lordship.
When you received the summons?
Very recently, Lordship, page, kindly see page 39, annexure 6, Lordship. I have annexed the summons, Lordship. Page 39. At that time, Lordship, next date was fixed as 9th of July 2024. And just a few days prior to this date, Lordship, I had summons, I have received the summons.
They issued on 17/5.
As soon as I received the summons, Lordship, then only, Lordship, I came to know this fact, Lordship. Now I am ready to appear before the learned court below, Lordship. At the time, 9/7/2024 was the next day, Lordship. Now, I have come to know from the E-Court Service Lordship that the next date is 25th of September 2024.
After receiving this summon, you approach this court.
Lordship.
On-
After an event, Lordship.
No, immediately on receipt of the summons, you approach this court.
Yes, Lordship. Yes, Lordship.
Okay. Heard. Mr. What is your name?
A.K. Ahmed, Lordship.
A.K. Ahmed, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Akhere Zaman, alias Akiru Zaman Sheikh, alias Akiru Zaman, who is apprehending his arrest in connection with PRC case number 235/2024. Learned counsel for the petitioner has submitted that on the basis of an FIR which was lodged by the victim girl on, where is the FIR?
Page 11, Lordship.
On
2/6/2018, Lordship, affair was lost.
2/6/2018, wherein it was alleged that the petitioner has committed criminal trespass into the house of the informant and raped the informant, and thereafter threatened her not to disclose thereafter threatened her of killing her husband, an investigation was initiated. And Mankasar PS case number 329/18 was registered and investigation was initiated. Ultimately, on completion of the investigation, charge sheet was laid against the present petitioner under section 448/376 of the Indian Penal Code. Learned counsel for the petitioner has submitted that the allegations leveled against the present petitioner are false and he is innocent. It is submitted by learned counsel for the petitioner that the petitioner came to know about the case only when he received the summons issued by the Court of Learned Chief Judicial Magistrate. Where? Dhubri? The Chief Judicial Magistrate? South Salmara.
South Salmara, Mankasar.
South Salmara, Mankasar, wherein next date of appearance was shown as 9/7/2024. Learned counsel for the petitioner has submitted that as from the summons received by the petitioner, it appeared that the charge sheet has been laid against him under section 448/376 of the Indian Penal Code. Hence, even after receipt of the summons, he apprehended that if he appeared before the before the committal court, which is a court of Chief Judicial Magistrate, the said court may not grant him bail due to the embargo of section 437 within bracket 1 within bracket small Roman 1 of the Code of Criminal Procedure, and he would be remanded to custody on his appearance. Hence, he approached this court by filing this instant bail application. Learned counsel for the petitioner has also submitted that the petitioner is ready to cooperate in trial and shall abide by any condition imposed on him by this court. On the other hand, Mr. Gogoi, what is your submission?
My lord, his conduct is not good. my
On the
lord.
other
That is
hand,
my
okay.
objection. my lord.
On the other hand, learned additional public prosecutor opposed the grant of bail to the present petitioner on the ground that his conduct is not inspiring and he may not abide by the condition imposed and hence bail may not be granted to him. I have considered the submissions made by learned counsel for both the sides and have perused the case scanned copy of the case record of PRC case number
235 of 2024.
235 of 2024 pending in the court of learned Chief Judicial Magistrate, South Salmara, Malkasa. Though it appears that the trial court, that the committal court has issued only summons against the present petitioner. However, it is also a fact that the PRC case number 235/24 is pending before the Court of Learned Chief Judicial Magistrate, Salmara, South Salmara, which may not grant bail to the present petitioner even if he appears before such court in pursuant to the note summons issued by it due to the embargo of section 437 within bracket 1 within bracket small 1 of the Code of Criminal Procedure, and the said court would be left with no other option but to send the petitioner to remand the petitioner to custody on his appearance. Stop. As this court is of, not as, this court is of considered opinion that as that if the petitioner complies with the condition imposed on him, he may not be required to be detained behind the bars during the pendency of the trial against him. Stop. In view of above, the petitioner, the above named petitioner is directed to appear before the. Now, only summons are there. No warrant.
Only summons.
When is the next date?
25th of September 2025.
Appear before the Court of Learned Chief Judicial Magistrate, South Salmara on 25th September 2024. That is the next date fixed by the said court with comma. And on his appearance, the said court shall allow him to go on bail of rupees 30,000 with one security of like amount, subject to its satisfaction with following conditions. Condition 3 condition. Abhishek Tarpuram. With above observation, this bail application is hereby disposed of.
Much obliged, Lordship.
Case number 36.
May I please, your lordship?
Diary not received. Yes, sir.
And FIR is faced for the,
Let us wait for, what is the offense?
my lord, offense is, my lord, the,
307 is there.
326,
When
307.
will you produce the diary?
Yes, sir.
How,
2nd of August.
how Mr. M. Islam, learned counsel for the petitioner, also had Mr. B. Gogoi, learned additional public prosecutor, who prays for some more time for producing the case diary.
31.
The prayer is allowed.
31.
Let this matter be listed again on 31st July
31st July, yes.
31st July. He has to bring 31st July 2024 for case diary.
Highly obliged.
37.
May I please, Your Lordship? This case, my lord, initially, well, it was registered as section 325, my lord. The FIR was lodged with the brother, my lord, of the deceased, with page 10, my lord. He was nowhere near the incident, my lord. My lord, his allegation is that, my lord, his sister was hit with a plastic chair by the accused. And my lord,
There was,
hit by a plastic chair
okay.
by the accused, which caused her injury.
Who is the accused? The
Accused,
present.
my lord, my lord, actually the brother-in-law of my lord, the deceased, my lord, and the nephew of the deceased, my lord. In fact, it's what happened, my lord. The son of the petition number 2 and the son of the deceased, my lord, had a quarrel in the home, my lord. It's a family matter, my dispute, my lord. Not dispute, they were there, these two children had a quarrel, my lord. And my lord, that was stopped. Now, after that, this lady, my lord, suffered a stroke, my lord. And the brother of the deceased, my lord, while on the way to hospital, he took her to the hospital, my lord, and lodged an FIR saying that, my lord, the brother-in-law of the deceased and, my lord, the son of the petitioner of one, my lord. Both of them had, my lord, had hit her with a plastic chair and caused her injury, my lord. My lord, under 325, my lord, the bail was granted by the, my lord, learned court, my lord, page 18. And, my lord, thereafter, this 302 was added, my lord.
Oh, she died.
She died, my lord. My lord, lordship will see the, my lord,
Now, bail was granted to both of them.
both of them, my lord, initiated.
Okay, then what happened?
Then, my lord, the police, my lord, made a prayer for adding of section 302, page 16, my lord.
Okay.
Where, my the medical report says, my lord, she, my lord, suffered, my lord, internal hemorrhage, my lord. It says both head injury as well as hypertension. my lord.
Okay,
So
no,
medical
but the question is you are on bail. Now you are on bail in respect of this case.
No, my lord, in the 325, I got the bail, my lord. Then
No, you have not got bail in with regard to a particular offense.
My lord.
But in a particular case.
Yes, that is there, my lord.
So you are already on bail.
But the police are again searching for me, my lord, and after adding this section, my lord. That is the difficulty.
Yes.
My lord, as per this thing, my lord.
How a person can be granted bail again in a case without cancellation of that bail?
Yes, ma'am.
Because he is granted bail
In a particular
in a
PS.
particular
That is true,
police
madam.
case. That bail order must have reflected that you are granted bail in so and so case.
Yes, my lord. That is there, my lord. Page 4, 18, my lord.
Where is the
Page 18, my lord.
so in Tamulpur PS case number 104, you are already on bail.
Already bail.
Unless this bail order is cancelled, you
Yes,
cannot be
that
arrested.
is there, my lord. But then after that 302, after it's been added.
Maybe. After addition of 302, this bail order has to be cancelled.
Cancel, my lord. Yes.
Then only you can be arrested. That is my
The
understanding.
difficulty is the.
Then this become infructuous.
the police-
I will make such observation in the order.
My lord.
Or what is your submission?
My lord,
Because you cannot be granted
True, my lord. That's true.
bail twice in a.
True, my lord. But then since the police is searching for me, my lord, again, my lord, they want, my lord. That's the difficulty, my lord.
You show your bail order.
My lord.
Heard, Mr. M. Mridmay, what?
M. Doctor.
M. Datta. Mr. M. Datta, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners Noor Jaman Ali, number 1, number 2, Nazmul Hussain, who are apprehending
No,
their
Noor Jamal and Nazmul are same person, my lord, and Jamal Ali, my lord. Noor Jamal Ali, my lord.
but
and
you have, no, you have named
Noor Jamal and Nazmul, my lord. I'm sorry, my lord. Noor Jamal and Nazmul, my lord.
Noor Jamal and Nazmul Hussain apprehending their arrest in connection with Tamulpur PS case number 104/2024. Learned counsel for the petitioner has submitted that the No, no, before that. The gist of accusation in this case is that on 21/5/2024, one Abdul Hakim Ali had lodged an FIR before officer in charge of Rongya Police Station, Inter alia, alleging that the petitioners have pushed petitioners had quarreled with the elder sister of the informant and they hit her with a plastic chair with causing her causing grievous injury on her, and ultimately she sustained ultimately she was admitted to ICU at Swasti Nursing Home, Rongya. Learned counsel for the petitioner has submitted that on registration of the on lodging of the aforesaid FIR, Tamulpur PS case number 104/2024 was registered under section 325/34 of the IPC. It is also submitted by learned counsel for the petitioner that both the petitioners were allowed to go, were arrested. They were arrested.
No, they surrendered.
Both the petitioner surrendered before the court and they were allowed. Where is the bail order?
Page 18, madam.
They were allowed to go on bail by the Court of Learned Additional Chief Judicial Magistrate. Additional Chief Judicial Magistrate where?
The
Mangaldoy.
you say Musalpur, madam. MUSH Musalpur, madam.
Rongya falls within Mushalpur.
Yes, madam. Baksa Musalpur, madam. Lordship, you can see the madam.
Oh, okay. The FIR was transferred to Mushal.
Transfer to Musalpur.
What was the last name? Additional Chief Judicial Magistrate Baksa Musalpur on 29/5/2024. However, it is submitted by learned counsel for the petitioner that thereafter the injured succumbed to her injuries and section 302 was added in Tamulpur case number 104/2024.
And just one thing. She died before that. Before this bail was granted, she had expired.
Okay. What was the? However, and thereafter the police are again searching for the petitioners, and therefore they have again approached this court by filing the instant anticipatory bail, apprehending their arrest in this case. I have heard learned case diary is there, Mr. Kaushik. Case diary is there. What is your submission?
My submission is already been granted.
There are learned counsel for the learned additional public prosecutor has submitted that from the case diary, it appears that the bail order granted by learned additional chief judicial magistrate on 29/5/2024 in Tamulpur PS case number 104/2024 has not yet been cancelled, and during the subsistence of the said bail orders, the petitioners may not be arrested again. Stop. I have considered the submissions made by learned counsel for the present learned counsel for the petitioner as well as learned additional public prosecutor, as well as I have perused the case diary of Tamulpur PS case number 104/2024. As it appears that both the above named petitioners are already on bail, which was granted to them by Additional Chief Judicial Magistrate Baksa Tamulpur on 29/5/2024. The apprehension of arrest by the above named petitioners does not have any valid basis, as the above named petitioner cannot be arrested again unless during the subsistence of the aforesaid bail order. Stop. Before they are arrested, and they can be arrested in Tamulpur PS case number 104/2024 only after cancellation of the bail granted to them by Additional Chief Judicial Magistrate Baksa Musalpur. Stop. In view of above, this anticipatory bail application is disposed of with an observation that at present there is no apprehension of the above named petitioner of getting arrested in connection with Tamulpur PS case number 104/2024.
Obliged, Lordship.
Item number 39.
In this case, petitioner is in interim lordship. He appeared before the IR statement was recorded lordship. In this case.
Well, item 39, we have received a CD, but without the statement of the petitioner. We would like to call for the up-to-date CD.
Okay, but he has appeared.
And that is not reflected in the CD.
Lord, I am appearing on behalf of the informant.
You are opposing.
There is the, yes, I am for the college authority. Now, your lordship, kindly see the order passed on 11/7/2024.
Yes.
Paragraph 5, clause 1. The petitioner hearing shall appear before the investigating officer within 7 days from today, and thereafter shall continue to appear before the investigating officer every week on a date we fix. Now, whether in terms of this order he has appeared or
Yes,
not.
Lordship, on 14 he has appeared. Lordship.
Every week you have to appear.
Next week he will appear, Lordship.
If you
Only 1
fail-
week there is there in last.
Okay,
14 he
so
has
you are
appeared.
on that. If
Your lordship,
Yeah, yes,
if your lordship see the contents in the FIR, my lord, he has swallowed more than 40 lakhs of the amount from the college fund.
no, let us wait for the case diary. Let us.
Yes, filed a writ petition before this honorable court. After filing the writ
My lord,
petition, they have received the notice.
my lord,
Lordship.
read petition, he has already been dismissed from the service. My lord, we called for my lord, the hearing was taking place. Now he said, I have filed a writ petition, therefore I am not
This is a
appearing.
Private institution, Lordship. They have private
So,
authority,
okay.
Lordship.
My lord, if it
Every-
is a private institution, how read
They
like?
have evaluate. all-
Wait for a minute. My lord, if it is a
One by
private
one.
institution, whether REIT lies, the REIT itself is not maintainable, man. And therefore,
Okay, no, let us wait for case diary.
All right.
We'll fix it next week. He
Right.
has to appear every week.
every
Lordship.
week.
Only it is from Karimgos. On
After
19
2
of
weeks,
April.
we will fix. If he
It's all right.
default, then you have a case.
Exactly,
Otherwise,
exactly.
heard Mr. A.B.T. Hawk, learned counsel for the petitioner, also heard Mr. R.R. Kaushik, learned additional public prosecutor, as well as Mr. S. Datta, learned senior counsel assisted by Mr.
That's the time.
S. Datta. Your all juniors are S. Datta. S. Datta, appearing for informant. Learned additional public prosecutor submits that though the case diary is available before the court, however, same is not updated and an updated case diary would be required for consideration of the instant anticipatory bail application, as the interim granted to the petitioner by order dated 11/7/2024 was granted with certain conditions, and unless an updated case diary is available, it may not be ascertained whether the conditions imposed are being followed by the petitioner or not. Hence, the prayer is allowed. The learned additional public prosecutor is requested to produce the updated case diary on
19/8, my lord.
19/8. The interim order shall continue till next day.
Obliged.
Item number 40.
My pleasure, Lordship. This is anticipated bail application, Lordship.
40
Can
CD not
this-
received, my lord.
In this case, Lordship, the petitioner is a boatsman, Lordship, and that their name is not in the FIR, Lordship. And
No,
up-
but CD would be necessary.
It is submission. Lordship.
Last order, last
Order
order.
also.
Go through the
You can
last
see
order.
good for CD, Lordship, but see, Lordship. Just little submission, Lordship.
No, it will be wastage of time because last order has been very specific that for consideration of this bail application, CD would be necessary. So we are fixing a date. Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed again on
31/7.
31/7.
Lordship. Obliged.
Item number 69 of supplementary list.
Yeah. 438 application, Your Worship. Yesterday the CD was available, but Learned KP asked for some time to go through the case diary.
Yes, the PP has changed.
I have gone through the case diary, my lord.
Huh.
Apparently, there are eyewitnesses to the incident who has implicated the petitioners, but the names they have mentioned as Papumoni Kakuti and Papu Das, but their father's name Telly.
One of them father's name tells but not
Papumani
both.
Kakoti
Papumoni Kakuti,
is the nickname of whom? Whose?
my nickname of my lord, that is not mentioned here.
No, but the petitioner is admitting that he has nickname.
Yes, Lord.
What is your nickname?
That is Bipul
He
Kakuti.
is known as Manoj and Papu. Both.
Who is known as Manoj?
Manoj is the Prasanto Das.
But
and
then-
the other
then-
is known as the Sampak is known as the Papu in his village.
In that case, my lord, Manoj is also named, my lord, specifically.
They have genuinely disclosed before this court, Your Lordship. And the thing is that this incident happened in the November 2022, Your Lordship. And till date, the search sheet has not been filed. And no police were searching for them at that period of time. And when now they have came to know the police is searching for them, they have inquired and they came to know that a case is pending in some name of this Manoj and
Charge sheet has not been laid.
not.
Charge sheet has not been laid because they all were responding, my lord. And there are eyewitnesses to the incident, my lord.
And immediately knowing the fact they have.
But
come-
police has not named Prashanta Das.
My lord, Prashant, as my learned friend stated, it is Manoj Bodole, Manoj, my lord,
Manoj?
Manoj Bodole.
Bordello is different, your lord.
My lord, 1 second, my lord, 1 second. Manoj Bordeloi, one is Manoj Bordeloi, two Papumoni Kakoti, and Papu Das. Papu Das' father's name is Nil Das. And Prasanto Das' name is Nilo Das.
My humble prayer, your lordship, since this charges has not been filed since 2022.
Kapur Mani's father's name is Nil Das. Yes, Mr.
Yes,
Kosh.
Nil Das, my lord.
And
And
Manoj Bordel's father's name?
village name is also same, my lord. And
Manoj Bordel's father's name is?
Corona Bordeloi, my lord.
So father's name also do not match.
My lord, this Sampak Kakoti, his name is, my lord, is Papumoni Kakoti, father name same, my lord.
What is father's name?
Bipul Kakoti.
And address?
Address same, my lord.
Manoj Bordello and Kakoti, your lordship.
So during investigation, they could not find out that Papumani is Sampak Kakoti. Because
My
it is
lord, that
a,
name has been written in the FIR. They are also mentioning the same name here.
no, the informant may not know the name of the accused.
Yes, my
But
lord.
during investigation, the investigating officer could have found out since last 2 years. It is
But
the
in
case.
that case, I may be allowed to take instruction whether this person are the same person, my lord. Because
No,
otherwise,
but there has to be some endorsement in the case diary.
but that endorsement is not here, my lord.
Well, that they have namely Prashanto Das, number 2, Shri Sampak Kakoti, who are apprehending their arrest in connection with Nagaon PS case number 1304/2022 under section 341/307/302/34 of the Indian Penal Code. The gist of accusation in this case is that one Doramai Soikia had lodged an FIR on 21/11/2023, 21/11/2022. When the FIR was lodged?
12/11.
12/11/2022, before the officer in charge of Hoibergaon Police Station, inter alia, alleging that on 8/11/2022 at about 9:30 p.m., the son of the informant, namely Kalyan Jyoti Saikia, and one Girish Nath, had gone to see Ras Utsav at Sensua Amar Borkakoti High School. And during that time, they had altercation with FIR named accused persons, namely Manoj Bordole and Papumani Kakoti. Manoj Bordole, son of Koruna Bordole, and Papumani Kakoti, son of Vipul Kakoti. It is also alleged in the FIR that thereafter, the accused number 1 named in the FIR knocked down the son of the informant on ground by riding a Pulsar motorcycle at high speed with an intention to kill him. And thereafter, no, not 2 accused persons. There are 3 accused persons named in the FIR. Manoj Bordole, Papumani Kakoti number 2, and Papu Das number 3. Thereafter, the other accused persons also came there and assaulted the son of the accused person, son of the first informant. Now, what is your submission that it was accident?
Yes, Lordship, it was.
But you were involved in the accident.
No, Lordship, I was there. We have witnessed the accident on that particular date. The village person also knows that it was an accident matter that had happened with this victim was. And later on, Your Lordship, the informant, the victim's
Who
father,
was riding the motorcycle?
that we do not know, Your
That is-
Lordship. We have just witnessed the
Learned
accident.
counsel for the petitioner has submitted that the allegations leveled in the FIR are against 3 accused persons, namely Manoj Bordole, Papumani Kakoti, and Papu Das, and the present petitioners are not named in the FIR. However, learned counsel for the petitioner has fairly submitted that as because the nickname of petitioner number 1, Prasanta Das, is Manoj, and nickname of petitioner number 2, Sampak Kakoti, is Papu. They are being searched by the police in connection with this case. It is also submitted by learned counsel for the petitioner that the son of the informant died due to an accident which occurred on the said date. and the petitioners had only witnessed the said incident on the said date. On the other hand, learned additional public prosecutor has submitted that has produced the case diary of Nagaon PS case number 1304/2022 and has submitted that from the case diary it appears that one Manoj Bordoloi, son of Corona Bordoloi, and one Papu Kakoti, son of Bipul Kakoti, were involved in the incident. He also submits that he may be allowed some time to take information from the
Another one person is also involved, Papu Das.
Papu and
Papu.
another Papu Das were involved in the, he also submitted that he may be allowed some time to inquire from the investigating officer as to whether the present petitioners are whether the present petitioner Prasanto Das is Manoj Bordole and whether Sampak Kakoti is Papu Kakoti or not. As in at this stage of investigation, in the case diary, the names of Prashanto Das and Sampak Kakoti are not there. The prayer of learned additional public prosecutor is allowed. He may be allowed to send back the case diary for updation and he may get the requisite information from the investigating officer as to whether accused Prashant Bordole, son of Corona Bordole, named in the FIR as well as in the charge sheet, is the petitioner number 1 Prasanta Das or not, and whether Sampak Kakoti, son of Bipul Kakoti, is the petitioner number 2. No, and whether the Papu Kakoti, son of Bipul Kakoti, is the petitioner number 2, Sampak Kakoti or not. Let this case be listed again on when?
My lord, on 5th of August.
5th of August. However, in the meanwhile, as from the case diary, it appears that presently the names of Prashanto Das and Sampak Kakoti does not figure anywhere in the available materials on record. Both the above named petitioners are directed to appear before the investigating officer of Nagaon PS case number 1304/2024 within a period of 10 days from the date of this order and shall cooperate in investigation.
Lordship, here my learned has already admitted that this petitioner number 2 and the Papu Kakoti is same. No.
Papu.
Papu, yes. Papu Kakoti, Papu Mani Kakoti, and Sampak Kakoti again.
Sampak Kakoti. We are not that person.
No, let him find.
তুমি কোনজনৰ কথা কৈ আছা?
দুজনৰ কথাই কৈছো. They are not the accused persons. They are wrong identity.
No, we are giving interim bail. If materials comes against them, bail may, if required, bail may be cancelled. What was the last line? Investigation. Stop. If they do so within the stipulated period of time, comma, in the event of their arrest in connection with Nagaon PS case number 1304/2022, both the above named petitioners shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority. Interim bail. Before bail, in word interim should be used. Subject to the satisfaction of the arresting authority. with following conditions. Condition number 1 and 2. Let this case be listed again on 5th of August, 2020.
Obliged.
Having item number 10 of court number 24.
Code number 21 है neki.
May I please, Your Lord? Lordship. My lord, petitioner was arrested on 24/12/2021. Today is about 2 years, 6 months, 29 days.
No, why these cases are coming to my court?
Because Lordship, the other.
Because I
accused-
granted bail in some cases.
There is a direction from the Honorable Apex Court. That is why Lordship. Lordship granted the bail to the co-accused out of same complaint, Lordship. It is annexed at page number 53.
When were you arrested?
I was arrested on 24/12/2021.
Where is the,
Hello?
where is that order of co-accused?
Lordship order is at page 53. Annexure D.
Oh, you were arrested later on.
Later on the basis of the statement of the co-accused, Lordship. That is at, Lordship will find at page number 43 of the final complaint.
Now, what is your submission?
My submission is that Lordship, in this case, in the final complaint, they have cited 10 numbers of.
What is your name? Papu Chakravarti.
My name is Kajal Devnath.
Kajal.
Here Kajal, they have mentioned by the arrested accused, my lord, but he was not identified. Kajal or Kajal Devnath was the same person. But Lordship, subsequently, Kajal Devnath was arrested in other case. Lordship granted bail to that case, and subsequently he was implicated in this case, Lordship. Only for Kajal Devnath or Kajal is the same person or not, that is not mentioned. And the mobile number, it is shown in the final complaint, that is also in not my name, my lord. So subsequently, I was implicated in this case, and they have mentioned, they have cited 10 numbers of witnesses in this case, Lordship. But out of 10, only 4 witnesses examined, Lordship, but in record only 2. Last witness examined on last 10/10/23, no? Last 10. Three numbers of witnesses. 3 numbers of witnesses examined, Lordship, out of 10 till today. And on last 16, it was fixed, no witnesses adduced, Lordship, by the prosecution, Lordship.
When was the charge sheet?
Charge sheet submitted on, Lordship, within 81 days. Uh, 1/8/2020. Sorry, 5 to 4 no 5 we do 5/8/2020 and 4 no 5 4 sorry 4/8/2020 and charge frame on Lordship 16/6/2023, Lordship. Because in this case, initially Sribas Das was the main person from who carried the contrabands in the truck. Subsequently, this person affected by HIV positive, and because of that reason, interim bail granted by the trial court during that period, Lordship, during the COVID period, Lordship, and subsequently this person, to our information, expired, Lordship, after granting that bail. That is why this case was, this case could not take up, I think, Lordship, but even then, thereafter, after framing of charge also, still could not in progress, Lordship. And because of that reason, Lordship, this honorable court granted bail to the accused person, Papu Chatterjee, Lordship.
Now, what material is there against Kajal?
Nothing, Lordship. Only the statement Kajol,
Whose statement?
Papu Chatterjee. Oh, no, Papu Chatterjee. Gobind Shah and Kajal, here Lordship, Gobind Shah is one of the accused person. And a CDR they have mentioned, but that CDR is not in my name. That is the only
You
allegation.
were arrested on 2/5/2019.
Who, Lordship?
No, Kajal was arrested on which date?
24/12/2021.
And the period of detention is?
About 2 years, 6 months, 29 days.
Lordship, in this case, Lordship, till 13/10/2022, the case status was production and appearance, Lordship. So maybe, Lordship, some co-accused was absconded. That is why I couldn't go through the record, Lordship. And as per the objection we have filed, Lordship, 4 witnesses have been examined out of 10, Lordship. So she is the supplier, Lordship. Sufficient materials found against
What
her.
material are against Kajal?
Lordship,
Apart from the statement of Papu Chakravarti, is there any other material?
Lordship, I have not gone through the record, Lordship. But Lordship, see, it is, he is the supplier.
See, no,
He. Lordship, he used fake SIM to conduct his illegal business like other traffickers, Lordship. Lordship, at the time of his arrest, he also using fake SIM to hide his identity. Lordship, sufficient, maybe there are sufficient materials available against him. That is why he was arrested. Those materials may
No.
be annexed with the.
We are concerned with this 359 kgs of ganja which was recovered. How Kajal is linked to this 350? He may be involved in many other cases. For that case, for that reason, he cannot be arrested in this case. In this case, he can be arrested only if he is connected with recovery of 359.5 kg of ganja. From your complaint, it appears that Papu Chakravarti gave statement against Kajal, implicating him, telling what Kajal used to do. Now, apart from the statement of Papu Chakravarti, what other materials the investigating officer have collected during investigation? That is,
there is nothing, Lordship.
and otherwise the delay of
Lordship, regarding delay, Lordship, regarding these grounds, Lordship, my senior already submitted earlier.
yes.
So those judgment may be considered, Lordship.
Okay. So, who is Akhilesh Pandit?
Akhilesh Pandit, one of the accused, my lord. The vehicle was in his name. Subsequently, it was transferred to Papu Chatterjee, Lordship. Because of that reason, Akhilesh Pandit was also arrested in this case.
Against how many accused charge sheet has been laid?
Against this person, Lordship, in the final complaint, there is nothing. Subsequently, supplementary charge sheet submitted in there also, there nothing, Lordship, because at the page number 23 and 24, front page of the final complaint, Lordship, only Gobind Srivas Das, Papu Chatterjee, Gobind Shah and Akhilesh Pandit. These are the person. Gobind Shah and Akhilesh Pandit was absconding that time, but he got bail, Lordship, from the Honorable Court. Akhilesh Pandit got anticipatory bail, Lordship. Then Gobind Shah arrested. He was in another case.
That is why he is still inside the jail. And Papu Chatterjee arrested lordship on summon. He appeared before the investigating authority lordship. Was Akhilesh Pandit was the owner of the vehicle, and subsequently it was
Now who are facing trial?
all are facing trial lordship, except Srivas Das. Srivas Das
He has expired.
split up the matter from him.
Okay. Where the Kajol
Kajal's name is not the final complaint lordship. Subsequently, he was arrested.
supplementary?
He supplementary. He has not made accused or any in the last of the final complaint. No prayer was there that his interrogation is required. Also at the page 46.
No. Now, what is the status of Kajol?
Kajal is inside the jail because of this case, lordship.
So he is facing trial or not?
Yes, he is facing trial. He is in jail, lordship.
On the basis of what charge sheet? Supplementary charge sheet?
Supplementary charge sheet one file, but on the basis of that.
Lordship, supplementary complaint has not been annexed, lordship. That is why I'm unable to assist you, lordship.
There is nothing, lordship. If lordship want to see, we can produce that.
No, unless I understand the case properly.
Lordship may be that we can produce that.
Because this case will otherwise remain in my court only.
Yes.
So I have to understand the facts first.
Yes. Punina, lordship. We'll see your
You come prepared, both of you come prepared.
Lordship.
Suggested it.
Any day, Tuesday?
Tuesday is okay.
No?
Okay. Heard. Miss N. Nargis. Sorry, Miss S.K. Nargis, learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel for NCB. Learned counsel for both sides. Prayed for some time to go through the scan copy of the LCR.
I'm sorry to interrupt, lordship. Can we check right now whether it is in the record or not?
Yes.
Kindly give me 2 minutes, lordship.
No, then I'll take some other case. You check.
If lordship may take up, if it is there.
No, you instead, we are fixing it on Tuesday. You go through the scan copy. Come
If it is
prepared.
then no problem, lordship.
Come prepared
Lordship.
finally.
Lordship.
Let this case be listed again on 23rd
July.
of July.
Obliged.
Number 24.
None appears for the petitioner on call. Let this case be listed again on 23rd.
Item number 13 of court number 21.
May I be lordship?
May I please,
Just a
your
minute.
lordship? Matter may be adjourned for the day.
Yes.
Just a
My
minute.
senior
Lordship,
will come.
Lordship, may I
No,
please? I'm
let
petitioner.
me first find out the
Yes.
case. Item number 13.
Admission committee.
Yes. Yes, what is
Yes.
the submission?
See, I have filed this petition for transfer of the case from CGM Golpa to CGM Borpeta. Reason is that lordship, please look in page 10 lordship. Both the complaint accused, they are staying in Borpeta. It is specially stated in that petition.
But
lordship.
she is not ready.
Yes, that's what I'm saying. But my view is a similar case already, your lordship, other courts have passed the stay order. I am feeling still stay order, stay only. Because they have appeared cases trying going on in Golpa courts. I am in Borpeta, complaints of Borpeta.
Your husband or wife?
No, lordship, this is a NIA case, lordship.
Okay,
Yes, same came. Similar case, the court has, in other case, lordship, this is, I mean, this state lordship. So my prayer is, they may be take adjournment only, I may be allowed to stay this proceeding lordship in the court of CGM Golpa lordship. Similar case in other court lordship. Same party lordship, responding is same. And here petitioner is other brother lordship.
what
In
is
this
your
case-
submission?
In this particular.
She's not ready.
Yes, lordship, but I'm only matter, I pray to stay lordship. Otherwise, case will continue because cases come admission column lordship. Because case is fixed on 23 at Goalpara lordship. So both the party has to appear. If your lordship has tried the case here, both the party can try the case in Borpeta lordship. Yeah, lordship, Aminul is the brother of Jiaul, brother, only both the brother and respondent is same lordship. We've given two check for our business purpose lordship.
What is your name?
Ma-
Aminul.
Yes, lordship.
And who is the, you are petitioner?
I am petitioner.
Respondent is Azmat Ali.
Yes, lordship. Here is also same, no, here is another brother, my other brother, who is Ziraul lordship.
Golpara to Borpeta. Golpara to Borpeta. So these two cases, how many cases were filed?
Two cases, lordship.
Were filed at Golpara.
They filed Golpara lordship.
One has been stayed,
Yes, lordship.
but that is a different case.
No. Respondent is same, here petitioner is due Pradupadas. In this is, Aminul is, this is 27 and this is 25 lordship. 25 already stayed, 27 is pending lordship, which is fixed on 23rd. The two brothers have got two check to respondent lordship for a business purpose.
You are not ready.
No.
Who is appearing in this case?
Yes, Ahmed.
Let Mr. Ahmed appear.
Yes, so
For-
I'm not quite.
No, for
married,
even
lordship.
stay at his back may not be proper. I am fixing a short
Monday,
day.
Monday lordship.
Okay. Heard Mr. D. Day, learned counsel for the petitioner. Also heard Miss, what is her name?
Akhtar.
N.
Akhtar.
N. Akhtar, submitting on behalf of
Yes, Ahmed.
S. Ahmed, who prays for an adjournment today on the ground of difficulty of the conducting counsel, Mr. S. Ahmed. Considering the ground, the prayer is allowed. Let this matter be listed again on 23rd July,
Since can it be 22 lordship?
22nd July.
Yes, sir.
Well, it is in the record. It is in the record. On 23rd we'll make it. All right.
Matao.
That is number 54. I think 54 to 68.
My lord, in this matter, other than 54, my lord may peruse the last order. That will reveal, my lord. And regarding 54, my lord, Miss A. Diane was appearing. She had some difficulty. She left. So, my lord, she made a prayer that this matter will be taken up next week, any day, my lord.
At
Petitioner
what
is here.
stage it is pending? Admission.
Actually, my lord, in item 54, all the matters, the stay order has been passed. But only in item 54, my lord, it was not tagged along with other matters. So there is no stay order. And hence, my lord, this was listed before your lordships.
But the 54th council is not there.
She has some difficulty, my lord, she left. So,
we
this is a
have
prayer. The next week, any date, my lord.
Okay.
Wednesday.
What is your name?
I am Ardhar, my lord. I am also standing counsel for Enforcement Directorate, my lord, ED. I am appearing in the other matters, my lord.
Okay. Ms. Gayan is also appearing for ED.
ED, my lord. There are a series of cases, so it is.
Heard Ms. P. Chakravarti. And for others, other councils are appearing. Heard Ms. P. Chakravarti. Whether common order is passed in all cases.
In all the cases, it is not lordships. Item number 67 is different lordship. Item number 67, CBI is appearing lordship. Their enforcement assigned to Malaga. 67, our lordship, they have challenged the order of grounded trial court lordship, whereby their petition was rejected to kept in abeyance.
What is the matter here?
Their lordship, they have filed a petition.
In 54 to
In all-
65,
all
what?
the matters, my lord, the common question of law is involved, that when the date when the offense is alleged to have occurred, at that point of time, this was not a scheduled offense under PMLA.
What was not a scheduled offense?
The offense for which the charge has been framed now, in fact, the trial court has not framed any charge, is in the stage of framing of charge. My lord,
In what case charge has been.
in fact, what has happened, my lord, CBI and PMLA, both the agencies were investigating into the same offense. The allegations are same. The CBI court is pursuing with the matter. It is in the evidence stage, and the same allegation, same set of the same ijahar, same set of evidence. Now, after some time, PMLA issued another complaint. Now, the question is, at that point of time, when the offense is alleged, it is in 2005. The PMLA Act came later on, my lord. So this was not an offense when the offense was alleged to have happened.
No, what was the allegation?
Allegation was that, madam, some
Misappropriation of government fund.
government fund, he was a banker, madam. He was a banker. So some draft were alleged to have been misappropriated.
You are submitting
No,
for 55,
two cases, lordship, yes, misappropriation of-
54.
54. So say, question in other cases also same, that whether, and on the date when the PMLA Act was not there, when it was not a scheduled offense under PMLA, whether this allegation would be maintainable. So,
In other cases, similarly type of petition already was passed, my lord. Probably that is her submission.
same.
So what should we do now?
She come.
No, let her take some rest. Before that, let me understand.
Lordship,
Mr.
yes.
One of you may,
Lordship,
Ms.
what?
Chakravarti may continue. Or Mr. Kamar may.
No, but it's our case first. We are in item 56, 59, 60, 61, 67.
You take some rest.
Yeah.
Madam,
No, I just want to understand the issue before passing any order.
But issue, if your lordship in a substance, I have to say, my lord, we have come up in the High Court against quashing of the order, taking cognizance because of the fact.
Cognizance under what of?
That is what, my lord. At that time, these were not schedule offense under the schedule. So.
The offenses for which cognizance has been
Taken, exactly. So PMLA has got no business to file charge sheet against those sections because that came into effect on 1/6. So all this transaction is prior to 1/6.
So now what has been done?
The stay has been granted. And in the meantime, one Odalipuram case, my lord, the ED department has gone for the SLP. That was heard once by the Honorable Supreme Court, my lord. It's reflected in the order sheet also. So in that event, my lord, the judge retired, one of the judges hearing the matter retired. So no judgment could be passed. So again, a new bench has been constituted. Again, a new bench has been constituted and now it is pending for disposal on that point. So when similar point is being dealt with the apex court, my lord, I think we should wait for that moment to come and see what order is being passed. Thereafter, we can proceed accordingly if any direction as such is given.
So this was pointed out to this court on earlier occasions.
Yes, many occasions.
And To that effect, the orders are also there.
Yeah, absolutely. Once or twice your lordship has also dealt with it. Probably.
I don't remember.
Last order is on 25/1/24. No, your lordship has also dealt it at some point. I remember it appearing before your lordship.
No.
It is there.
Is
I
it?
believe, man. If my memory has not faded, my.
Yes,
Hello?
my lord, for example, 29/11/23. Yes, I have.
চাই ল'ব তাতে চাই ল'ব কৈ দিয়া খালি অৰ্ডাৰ শ্বিটটো চাই ল'ব ডেটটো কৈ দিয়া 29 নাই ঠিক আছে पहली पहुंचेगी तब वो की होगा डेट लो ठीक है हमने आपको तो कर लिया तो साइकिल पे समझते हैं ऐसे नहीं
Okay. So, yes,
My lord, there is no stay in our case, my lord. Item number
54.
54
So on that interim, regarding the interim part, my lord, matter may be heard on 25th, my lord.
you're opposing.
Yes, I am opposing, my lord.
She's vehemently opposing, but I
Yes,
don't
sir.
know why, my lord, all other cases in.
On the
the same
25th,
issue
my
have
lord,
been
if honorable
stayed.
court satisfy on her, it is up to lordship, my lord. That is maybe at least one time maybe heard. 25th, my lord.
जुलाई
Not consider. Next তোমাৰ কেতিয়া আছে হেৰি তলৰ কোট কেতিয়া আগষ্টত আছে তেতিয়াহ'লে আগষ্টত ফাৰ্ষ্ট উইকত জুলাইত তাতে আৰু বহুত দেৰি
So then whether this will remain tagged with the other cases, because each
normally similar point is involved that's why it has been tagged
Actually,
that-
lordships wanted to see the other cases where what
Order has been passed.
Therefore, when it has been tagged.
8/9, my lord, otherwise August 8/9.
basically it is for her method that
Yes,
all
exactly.
our matters are tagged
First take it, then before 5th, 25th.
all right
No, হ'ব দিয়া একো নাই।
Okay. It's a common order.
Lordship, before your lordship passes an order, with regard to item number 67 also, there is no stay order. And the fact of the case is different. Fact means, I mean to say the challenge. in that-
67 is also tagged.
67
yes,
is also tagged, but the challenge in that petition is something else, lordship.
that's true my lord it's for the CBI but since it has been arising out of that CBI case because under section 45 of the PMLA Act the same court must try so since this is stayed my lord the predicted offense is also automatically stayed that was the
was not
issue
stayed.
so we'll address it in some other day my lord.
It was not stayed, lordship. 67 was not stayed by this honorable court, lordship.
In
We'll
item,
address it my lord.
in item number 67, there is no stay.
No stay order.
No
From this
stay.
No, because of the fact that in the CBI case, that is a predicted offense. Because of that, PMLA case has given a rise in minor. So the court which will now, there is a law, probably section 45. So which says that the case which is to be tried together, both PMLA and the predicted offense case, minor. So that's why it has been tagged together, minor. So we'll address it, a date of hearing may be fixed, will satisfy your lordship. So he can.
My lord, may fix on 2nd of so that I may be able to file affidavit objection
My
in
lord,
the meantime, my
she's
lord.
been taking time for
Second
this, my lord, for at least 4-5 times. This has been listed on this issue that whether my case also should be
Then,
stayed,
my lord, before
Why,
any
my
date, my
lord,
lord.
my
In the
case
meantime, I'll
cannot be
file my
stayed?
objection,
I don't
my
know, my
lord.
lord, what is the objection? All other cases are
Let
same
her,
issue.
let her file objection.
But
Yes, ma'am.
she has taken time at least 4-5 times only on this pretext that she will file objection. And my
But
lord,
that was hard
the, no, no.
But
you can-
actually, what is the fate of that case? It is actually proceeding or
Yes,
stay?
my lord, that is the difficulty with me.
What is happening
Which is
in
the
there?
charge-
What's the stage?
Charge
stage.
framing of charge, my lord.
That is on 5th of August. As
Charge has been framed or
No,
for,
not yet, my lord.
so we are fixing before 5th of it
Yes,
on 2nd of August.
2nd of August, yes.
Sorry, so on, from 31st to 5th of August, I will not be there, lordship. I'll be out of it.
31st to 5th.
5th of August.
Then
Next week, my lord.
30th then,
Yes.
30th,
30.
30,
30,
30 of July.
Okay. Heard. Common order for all.
yes,
Heard Miss P. Chakraborty. Mr. Who is for 55?
55 it is, it's your case, 55
No,
or 54?
54.
55 none is here, Chopra. It is.
Also heard Mr. Z. Kamal.
I'm appearing in 56, 59, 60, 61, 67.
Z. Kamar, learned senior counsel, assisted by
Nazmin. And Begum, Nazmin.
N.
Begum.
Begum. And Miss Chaudhary, you are appearing for? And Miss B. Chaudhary. And who else is there for petitioner?
My lord, I am for 63 and 68, my lord.
Mr. B. Bora. D or B?
D, my lord, D.
D. Bora.
Slip on DD. We'll give the slip, my lord.
63 and 68, my lord.
Okay, also heard Miss
Slip upon bonnet. No?
A. Gayan for enforcement director. Who else is for enforcement director?
I heard.
Mr. R. Dhar. As well as Mr. M. Haloy for appearing for CBI. Learned Counsel for Enforcement Directorate, Miss A. Gayan. In criminal petition number
932.
932/2019 has prayed for some time for filing written objection against the prayer for stay filed by the petitioner side. The prayer is allowed. The Enforcement Directorate may file written objection in criminal petition number 932/29 on or before 29, before 37,
Before.
2024 with a copy of the same furnished to the counsel for the petitioner. When 67 will be heard,
67 lordship, subject matter is different lordship.
but it can remain tagged now.
It's already order is there.
Because.
But let it remain tagged. If you require it to be segregated, you may
Can be
make a
segregated, Lordship,
prayer
because- yes.
later on, not now, not today.
Now we'll take it together on 30th, man.
Let these cases be tagged together, remain tagged together, and be listed again on 31, 30, on 37, 2024. The interim order granted earlier shall remain.
No, for her, because our two is going on till Supreme Court's disposal, my lord.
Until further on.
Time is not.
Only
in-
for
only
her
for
case, my lord.
Item number 50.
Only for her case what?
That
only
interim
that.
order is to be passed or not passed in
That
conformity
we
with the
will
other.
discuss on that day.
Yes,
Yes,
madam.
madam.
The interim, wherever interim order is granted, same shall continue till next day.
Where?
List accordingly.
67 there is no interest, so it will not be.
Yes.
Wherever it is granted, it will.
Yes. ma'am.
Next letter that has- Our next letter that has-
Anything left.
But actually, there is an order dated
25-1.
Kaushik Goswami.
There on record.
That has been made signed by.
I'm done, but it has again been listed.
No, this,
Because of him.
your lordship has now.
There on record, I have furnished.
Then there is no necessity of,
Yes, actually,
Further
that is,
order.
if your lordship will kindly tell us 25/124. I shall read for your lordship convenience. Heard both sides. It is submitted that the bar that the similar issue is being considered by the Honorable Supreme
No,
Apex Court and
okay.
accordingly seeks posting of the matter after consideration of the
In-
issue resolved by the Honorable
the
Apex Court.
interim order shall.
Considering the above submission, the matter is adjourned signed die.
Shall continue until further order kati dibo. Shall continue full stop.
Wherever it has.
Wherever it was granted earlier.
Earlier.
That will be better.
That will be.
Much
Next.
obliged.
Finish.
Last of this.